Charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I mean, they've got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican police service Latino. I didn't ask you to interrupt.
Is that correct?
Oh, for Trump's sake.
Shame on you, sir.
Shame on me, sir. Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. And my audio is all messed up. Had some technical difficulties this morning trying to work through them, and buttons are not working again. What did I do last time to fix all the buttons? Anybody know? If anybody knows, it's going to be Kim. Kim, congratulations, or good luck. First in chat today, there we go. So you're in charge of the internet. I think this is internet related, Kim. I think if you can fix the buttons, that would be great. Let's see. I just don't understand why it's not working. Oh, I think I remember. Kim, you might be off the hook, Kim. Hang on one second. Let's see. Let's turn that off and back on. And then let's turn this one to 0, save, then edit again, turn it back into the other port, 9, save, fingers crossed, deep breath, did nothing. Kim, it's still broken. And I don't know why. Let's just try to turn this off and back on again completely. All right. Good morning. Happy Monday to you. Hope you had an excellent Easter weekend. See what I did there? Excellent. We have one more day before everything breaks loose, unless, of course, you're Lori Vallow, and that's today. Lori Vallow, I think we're going to do closing arguments today, starting around, I think the jury instructions are like 1 or something like that. I have to look at the schedule again. But, okay, let's try. Did that work? Yes. I fixed it, Kim, or you did. You probably did it on your end, and I'm taking credit for it. I apologize for that. But either way, it is now working, which is the important thing. So buttons are up. Now we won't touch anything for the rest of the week. All right, welcome one and all. Hope you're having a great Monday. Didn't realize we have court today. Well, it's like an extended weekend. Exquisite. It was exquitric morning. That's a tough word for me. I'm not even sure if it's spelled right. Wogger. First day I've ever seen that word was today. Tells you how you did it so we can assist you next time. Okay, Apple Treasure. I reset Mix Effect. Mix Effect is an app built by a gentleman named Adam Tao, and he programmed all these buttons, like all 78 pages. He made the entire app there, so I bought that, and then I bought the Mix Effect that goes with it. And together, they interface with Companion, and Companion sends commands to my switcher. So the 4 pieces together make things work. It's a lot of effort just so that I can not have to push these buttons right here. All right. Good morning. Let's see. We have Tammy Dunlap birthday today, and Sarah Kay. This is great because for those of you who don't know, the Tammy Dunlap we're talking about is the Tammy Dunlap who makes pancakes for everyone else. Why is my camera crooked? Why am I way over here? Can we not do that? Nope. That's where we live. We live here now. We are here now. It's all good. Wogger says I made up that word. Okay, excellent. I was worried that my vocabulary was not what I thought it was. We have Tammy Dunlap. It's her day. I actually talked to her over the weekend. It was great. I think on Friday. Friday we talked. Let's see. Let's sing happy birthday to Tammy Dunlap and Sarah Kay. And Tammy has to make her own pancakes because that's how we roll around here. Sorry if this is loud, but everyone stand up, take a deep breath, shoulder back. Good. Thank you, Judge Fleischer. Shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. All right, we're going to sing happy birthday to Tammy Dunlap and Sarah Kay. Happy birthday to you. Happy birthday to you. Happy birthday to Tammy Dunlap and Sarah Kay. Happy birthday to you. Tammy Dunlap and Sarah Kay, it's your special day. There are a million places you could be, a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor is ours. Hopefully we can turn some of that joy back to you and make your day a little more special. And begin by helping yourself to free pancakes at your own house if you're Tammy Dunlap. Or Denny's, IHOP, Village Inn, Waffle House, McDonald's, Bob Evans, or Andy's Grill. Or Tammy Dunlap's house if, Sarah, if you want to just come over. Come on over. Pancakes are hot. As is my mic. It is like smoking in here. I think it's that one. Let me just turn it down just a notch or two. All right, there we go. Twerk, spin, pirouette. There's a move I haven't seen in a while, Kaylee. You pulled it off. I'd give it at least a 9 out of 10. Twerk, spin, pirouette. Not one you always see it when you go to the theater or like the ballet theater. Is it? What do they call it where ballet is performed? Is that still a theater? The high kicks are quite impressive. Anytime I get my feet above my knee level, I'm counting that as a win. So, Judy M is belting it out in the bathroom. We can hear you, Judy. Sounds great. Breakfast, lunch, and dinner. Yes. Here we go. Big air drum finish. Grab your air drum sticks. Sit down to your air drum set. And let's do the big solo finish. I guess I could sort of do the boom, boom, boom. I could do the hi-hat and the snare leading up to the big finish as well. We could drum the whole thing. I know some of you wouldn't mind if we 80s Music Man, you were banging the drums like no other. If I could just pick up my legs, it would be a good day. Some days, Dr. Bob Gaming, some days I'm there with you. Wow, what a day. I posted some pictures on I think it was a YouTube post on Saturday. We did yard work. I mean, we got the pressure washer out. We were first of all, getting the pressure washer out involves a Herculean effort because it's down in the basement, which really is. We don't have basements in North Carolina, so it's not quite tall enough to stand up in, but it is sort of like a hole that's dug under our house. And I say that because the house was here first, and then the hole was dug, and then they sort of cemented the walls. So the walls are like built to try to keep the dirt back, and it does a pretty good job. Whoever did that was great. It's fantastic. But so you have to go down these rickety old steps, which one of them is broken, and the bottom one is broken. And you go down to the cave cricket dwelling, and you're looking around, and you're hunched over like the Hunchback of Notre Dame because you don't want to hit your head on whatever nails are sticking out of the rafters above you, and you have to find the air or the pressure washer with the hose and everything, and then you have to grab it and carry it up those steps. You can't drag it. I mean, it's designed for being pulled around the yard behind you on a flat surface. But no, you have to carry it up these steps and then through a little narrow door, which it does not fit in. You have to like ram it through the door because the door was so narrow. Then you get it outside after you go down the other steps because you have to go up through the house to go back outside. Then we chose Saturday to do this because our renter was gone. And the only outdoor water spigot we have on our property is on the rental unit. And so if we turn on the water, it sounds like we're using his water. Well, it's our water. Okay, we're paying for his water. That's really how it goes. But we don't want the noise or anything else. So we fired that puppy up. We cleaned off the whole brick patio. By we, I mean not me. And we cleaned off the driveway in front of the rental unit. Just scoured the driveway, just made it shine. Cleaned that off. Blew all the mud into the neighbor's yard. It was delicious. It was great, and tons of work. I did a little weed eating on the front edge. Got the weeds down, so you can now see the house from the street. That's good. But my back's feeling it today, so I did sleep in just a little bit this morning for that. Had a wonderful Easter yesterday as well. Beautiful, beautiful Easter service. Got to do a little bit of live streaming that I wasn't planning on at the last minute. And for the church service, but we pulled everything off, got it together. And Susie, you're considerate owners. The thing is, we target traveling nurses for our rental. Like the website we go through and everything, it's for it like the only people that use it are traveling nurses, and they have screwed up schedules. I apologize, but they do. They get the crappy schedules, the weird shifts, and so when they're home, it's because they're sleeping because they've been working for the last 12, 14 hours. So we always, we don't want to turn on our patio lights that might light up their room because, that would be bad. Hey, Miss Story, how are you doing? Good. So we try to be considerate, but they were gone, so use the pressure washer. And Mrs. R.A. and my daughter, fantastic. They just, it looks, it's like a whole new yard out there. All right. Next job, kids, build a step. Research estimate. I go. Yeah, we might need to replace that one step. Yes, we have screwed up schedules even when we aren't traveling. Speaking of screwed up schedules, today is a little bit screwed up because we don't have a ton happening. We've got Lori Vallow, who is about lunchtime, about 1 o'clock. They're going to kick things off. And then Karen Reed starts tomorrow. Wow, can you believe it? Karen Reed starts tomorrow. Susie from San Francisco, can you rent from me? If you're a traveling nurse, we don't do like super short rentals, like a couple days. We don't do those. We usually do 3 months at a time, but we also don't do really long rentals. So it has to be the rules for the Airbnb pretty much are discriminatory against everyone but traveling nurses. I don't know what else to say. Can't wait for Lori Vallow, Daybell, jury instruction, then lunch, then closings. Kaylee, do you see a verdict today? It seems like they're taking their time in these last few things, and I'm not sure. It might be late tonight. Nurse for God, where's Mr. Frog? Nobody knows, and I think honestly the court does not care at this point. I missed some generosity. Let me go back up and catch that. Just 1 minute. Thank you, Samantha. Can't think of a better name. Member for 2 months says, I'm ready for air drums. Thank you very much I heard you play, and it was beautiful. It was beautiful. You've clearly been practicing. Jamie C. says, I ended in a Dallas Cowboy cheerleader's jump split, and I can't get up now. The Dallas Cowboy cheerleaders jump split. It's not like just a cheerleader jump split. It's the Dallas Cowboy cheerleader jump split. Which for some reason carries a visual with it that's different than all other cheerleaders. So, go ahead. Yeah, you're cool. Kids are building in the other room, so it's going to get a little noisy, which means we need to probably start watching some court, which is what we came here to do. We're going to start with Judge Dad because he's got a lawyer in there who has all the books. You're going to see this here. Hang on.
ZYDLOWSKY. I'll spell it again. MOCZYDLOWSKY. That's 2500367 is our case number, okay? And I
Thank
will
you, Judge.
send that out, and it looks like we're all set on that.
Thank you, Your Honor. Thank you, Matthew.
Thank you both. Have a
No
good
problem.
day.
Thank you, guys.
Matthew's in the library.
PCA of Acquisitions versus James Radford. 2500389.
I think they're just summary judgments here.
Good morning, Your Honor. This is Natasha Dixon on behalf of the plaintiff. My P number is 82333.
Good morning to you. And let me just find this. Give me 1 second. Is Mr. Radford here?
I have not had him check in, Your Honor.
Is there a James Radford out there?
Paging James Radford. Paging
All right,
James
this
Radford.
was scheduled this morning for.
There is somebody on an iPhone, but he doesn't have his audio connected. I'm asking him to unmute.
15, unmute, start your video, and tell me your name, please. iPhone 15.
What if it's one of us?
My name is John Hazy.
You have to start your video, sir.
Oh, okay. Sorry.
Right.
All right, you have to take your hat off, too. Ms. Dixon, I'm going to let you just go ahead and proceed with a default judgment. The defendant is not here, and we'll go from there. Give me your breakdown, please, real quick.
I'm sorry, Judge. Yes. So the damages are, damages is 1,499.46. That's 1,499.46.
Give me your costs.
Yes. So there's an attorney fee of 75. The summons filing fee is 55, and the summons service fee is $37.06. I'll give you total
That's
of that.
That's 157.06, right?
Yes, sure. So the court cost will be $92.06 and an attorney fee of 75, and the damages. I can give you a total of that, Judge. Okay, just make sure I have it right.
Should be 1657 or 6.
Yes, just 122.
Right?
Oh, yes, Judge. I'm getting it's 1,666.52. So that's 1,666.52.
Right. Thank you. 166.22, right?
52, Judge. 52. 1,666.52.
I see it's 46 and 6. Okay, got it. I'm sorry. You can go ahead and submit your default judgment in that amount, and I'll ask you to do that as soon as you can, sometime today or tomorrow at the latest. Thank you very much.
Will do, Judge. We'll submit a default judgment. Thank you.
Thank you.
I ate the last of the enchiladas yesterday.
Capital One versus Gutton. Michelle, we got 2404651.
Ready, Your Honor.
Good morning, Mr. Best. Your name?
Good morning. Stuart Best of the firm of Weltman, Weinberg, and Reese on behalf of plaintiff. Capital One.
We'd never know what firm he was with if he didn't tell us.
Good morning. I'm Michelle Gutman.
Gutman, I apologize. What do you have? Did you two talk? Do you owe this debt, man?
Yes, I do.
Counsel, it is for $2370.25 plus filing service and statutory attorney fee. Do you want to go into a breakout room, see if you can resolve it with consent?
Yes, please.
Okay, we'll put you two in a breakout room, and either way, you're coming back in front of me then, okay?
Yes, Your Honor, and I've got another one in front of you as well in a few minutes. So
Okay, good enough.
Thank you.
TD Bank versus Jamie B. Wakefield, 2404096.
We're going to jump to a different court to see if they're doing something.
Good morning, Your Honor.
And that right?
Yes.
Are you waiving that right?
Minecraft.
Yes.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yeah.
Yeah.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yeah.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a
sure about
lawyer,
that
one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yeah.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, I understand them.
Do you still want to plead guilty to this charge?
Yeah.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time that I could sentence you to prison, to jail, or to community control?
Yes, I understand.
Now, the offense of attempted failure to notify is a felony of the 4th degree, and it carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
Do you understand that if a prison sentence is imposed in this case, that you might have to serve a period of post-release control as part of the sentence?
Yes.
After your release for up to 2 years under the parole authority?
Yeah.
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you that I would go easy on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
What was that?
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand at the time of sentencing, I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yeah, I understand.
Have you had enough time to talk with Ms. Smith before pleading guilty today?
Yeah.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yeah.
Do you have any questions? Do you have any questions at this
No.
point? All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that in January of 1993, defendant Mark King entered pleas of guilty in 2 different cases in Lake County Court of Common Pleas. In 92 CR 000568, he pled guilty to 2 counts of attempted rape, aggravated felonies of the 2nd degree, and 1 count of gross sexual imposition, a felony of the 3rd degree.
Okay, now we're going to bail.
000631. He pled guilty to gross sexual imposition, a felony of the 3rd degree, on February 19th.
Show cause, it has to be
And we're
by
out.
first-class mail, just by first-class mail. At least
He's
10
got a
days
record.
before the show
I don't want to
cause.
stick around to see what he's getting now.
She doesn't show up, I'm gonna issue a warrant for her arrest, okay? Does that make sense?
Yes.
So I wanna make sure you understand, when you subpoena somebody, they're supposed to show up, it's a court order, I don't know why she didn't. I always give them the benefit of the doubt on the civil cases, and we issue a show cause. If she doesn't show up next time, I'm gonna issue a warrant for her arrest, okay? So you can go down the hall, and they'll give you a order to show cause, and they'll give you a date, okay? Best of luck to you.
Thank you. Have a good day.
You two, Automotive Club versus Dion Glenn.
Let's see if we can find another thing. Let's see if is Judge
Two
Simpson doing
OWO.
anything? Well, my boys are screwing in the.
Is somebody here on this from Auto Club? Is somebody here from the auto club on this?
It's getting awfully quiet.
I don't have anybody out there.
Okay, so just for the record, what happened is, you were here April 1, plaintiff attorney says the Garnishment defendant, not certain. Or, I don't know, I said, Linda says otherwise. They adjourned the hearing, peer service not conducted appropriately. Okay. Peer service not conducted appropriately. Didn't even bother to call us and say anything like, hey guys, we agree with the judge, we're not showing up. I mean. Linda, am I right?
I'm sorry, Your Honor. What did you say? You sound muffled.
I know what's going on here. Are you guys hearing me, or is it only when I'm up to this level?
Yeah, I can hear you much better when you're closer to the microphone.
We gotta talk.
It's funny how that works.
We gotta talk to Sheen. At any rate, I just was hoping that somebody would call and say they're coming or not coming. They're not here. I'm assuming they didn't. That they agreed with me that the service wasn't appropriate. But the bigger issue is law firms, frankly, sending in proposed judgments on garnishing defendants who are not served in accordance with the court rule. And it troubles me greatly because if it was only one a year, that'd be one thing. But I got to tell you, 80% of these I get against garnishing defendant corporations are not served appropriately. So I'm going to talk to the civil department and I'm going to tell you guys how I want you to proceed. But this is just, wow.
Okay.
We got to make sure that doesn't happen. I'm going to go ahead and deny the motion for summary disposition. This did not, they didn't show up. So I'm going to deny it. See above. So it's denied versus the garnishing defendant, but this was for over almost $15,000 submitting a judgment against the garnishee. And again, these aren't my rules, I just know what they are. Apparently, a lot of lawyers don't know how to serve a garnishee defendant. Actually, I have to say the great majority don't know. So that's all I can say. I'm going to go on to another case, people against, in fact, I'm taking a 5-minute recess. Everybody stay seated, please.
In fact, I'm taking a 5-minute recess. He's mad. He is so frustrated. He's like, I've been doing this for too long to have you guys not know how to do this.
Yeah, no worries, Judge.
Whoever calls me.
Of course, we definitely want to
just give him the stuff that she gives me.
Have him be calm, cool, and collected for hearing whatever case is coming up next.
You know what I'm saying?
Here's one.
What's that?
Let's jump to Michigan here. Here's one I haven't seen before.
Driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. The 86th District Court will email you a copy of the referral form regarding the testing requirements. They begin immediately, so make sure by 3 o'clock this afternoon that you do get that referral form so you can begin that testing.
So, Your Honor, with regard to the no possession of alcohol, Mr. Elmy did share with me that he's hoping to be able to also go back to work to Apache Trout Grill. So we would ask for a work exclusion if he does, or exception, pardon me, if he goes back to work, that he would be able to be around it or possess it if necessary for work purposes only.
Well, for right now, since it's, he's, you know, involved in this other job for which he's a supervisor of some sort. And that's only a possibility. I'm not going to put the exception on, but his attorney certainly can review that once again and file a motion with the court, or at the time of the pretrial conference, bring that up.
Do you understand, Mr. Elmy?
Yes.
Okay.
are you testing in the other case?
Yeah, I've been doing testing at New Direction.
Okay. And are you testing daily?
Yes.
Okay, I'm going to change it so that it's all the same in this one too. Are you also taking urine screens?
It's been like once a week.
So 4 times per month urine screen. So I'm going to make it all the same so it's not confusing, right? So it will be daily PBTs and 4 times per month urine screens.
Okay.
So it's all the same. So you don't have to have different words that you're looking for, you know, as far as the urine screens are concerned, it'll all be the same. Okay.
Okay.
Sorry about that, Dana. Miss Mistily, is there anything further?
No, thank you.
All right. You still have to have an immediate urine screen, a benchmark urine screen today. Again, you'll be testing the same on the same schedule as you currently are in the other case. And do you have any questions, Mr. Elmy?
No, ma'am.
You'll hear from your court-appointed attorney by the 1st of next week, so please watch for that. The court will mail you a notice regarding the date and time of the pretrial conference. I appreciate your appearance this morning, and you are free to leave the meeting.
Thank you so much.
You're very welcome.
Bye.
Well, trying to figure out what that is behind her. Is it a picture of the courthouse?
Who do you have with you this morning, Mr. Slocum?
Leah Pringle.
Okay, if you would hold on for just a moment, please.
No problem.
Mr. Alejandre, I can't hear you. Miss Mistily, did you have opportunity to speak with Mr. Alejandre?
I did not.
Okay. Well, he's having issues right now with his.
It's where the judge should be.
Audio.
She's not.
I
think she has a physical picture behind her.
Mr. Alejandre, can you hear me?
Like a poster mounted on the wall. Sort of funny.
You may need to stop your video and use the audio only. That might give you more bandwidth, more comfort. I'm going to put you in a breakout room with Miss Mistily so that she can go over the issues regarding the arraignment before we begin.
We're going to see if we can jump to another one here.
Maybe I'll just wait and see if he unfreezes. So, okay, we'll get back to Miss Pringle. I'm sorry, Mr. Slocum. We're on the record in case number 25-4170 SM, and you are Leah Pringle. Is that correct?
Yes.
You're appearing for arraignment purposes this morning. You're appearing with your attorney, Mr. Slocum. And Mr. Slocum, did you have opportunity to review allegations on the complaint, nature of the offense, and the possible maximum?
Not a shield for her. She's just trying to get a leg up in the guardianship proceedings and all. That was so loud. That's not in evidence.
What's that?
It's not in evidence, and it's sort of
this picture is crazy.
Excuse me. There's no report in evidence that I have an ability to use to rehabilitate or cross-examine or do anything like that.
Right, and I'm not really here to litigate the POA or the issues dealing with the guardianship or conservatorship.
I'm awake.
Those are issues that may be handled down in Indiana. Is that correct? Because I'm showing it. Does the mother live in Bristol, Indiana, 21391 Southern Court? Is that where she would reside?
Yeah, I have the filings here, Your Honor, if you'd like to take a look at them.
And so the issues I'm really dealing with are other contacts between Mr. Lemke and her. And I understand the foundation and the particulars, but I'm not here to deal with really the reasons why. I mean, you can't harass somebody regardless of the reason, even if it is.
Even if you've got a good reason, you can't harass them.
I understand that can cause it, but love relationships.
I'll move on. I'll move on, Your Honor.
Did you ever tell Mr. Lemke to stop the communications between you through text message?
I did not text him those words, no.
Okay, did you ever tell him orally to stop calling you or communicating with you?
No, I did not.
And communication was ongoing because of the authority of you acting as power of attorney before that, correct? Regarding your mother, there were communications between you regarding your mother.
Yes, we had many communications, and some were not harassing, some were like just informational. We were trying to support our mom.
Now, you said that he had called you a narcissist in one of the text messages, correct?
No, he called and told me that on the phone and yes, both.
All right. So I'm going to show you what's been previously marked, what's being marked. Let me see. Defendant's Exhibit A.
All right. There's a little tiny inmate in the corner.
Thanks. Ignoring the side of communication.
Just can you identify, is that the December 3rd? What's on the top?
December 2nd through December 10th.
Okay.
And this is being marked as Defense Exhibit A.
I have no objection to it.
This is separate from what you got, though.
Oh, okay. Okay.
So these?
Not this part right here. This is the communication.
I can't read it, I'm sorry, I don't have my glasses.
You have glasses?
Okay, sorry. Thank you.
My pleasure.
Oh, yes, that's when he was trying to, yeah, we did. We talked about, after that happened, okay, this is, I see what you're saying, that about Lisa lies, because I called him and I said I did not call, he called me. Yeah, I called him.
Now, if you look at the bottom, he's wishing you a happy birthday first thing.
Oh, I know, yes.
After he called you a narcissist, right? Yeah. And then you said, aw, with the heart emoji, correct? You said thank you?
Sure, yes.
Move to the Exhibit A.
No objection.
So we'll see response today.
Looking for another court that might be.
Nothing further, Your Honor.
Any
might be
No.
live.
Step down there. Attorney Anthony, do you have any additional evidence to produce?
We have no additional evidence right now.
All right. And Attorney
Call Mr. Lemke.
Mr. Lemke, why don't you come up to stand here if you would? Can you raise your right hand if you would, please? You solemnly swear or affirm that under the security of the testimony you will give in this matter, not pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you.
Please see if you would. Please state your full name for the record and spell your name.
This is a harassment case, I think.
Larry Michael Lemke, L-E-M-K-E.
All right, Attorney Bray.
Thank you. Mr. Lemke, you heard your sister's testimony here today.
Oh, sister.
Yes.
And she stated that you screamed and berated her on the phone at some point. Did you hear that testimony?
Yes.
Do you agree with that testimony?
No, I do not.
Do you know what date she's referring to and what conversation?
I do not. I don't. She would have been calling me and yelling at me since December. The first time, I believe, was at the bank when I texted her. She told me that the First Source account, which Key Bank had told us to close and take the money to Key Bank. My mom was nervous that her bills weren't getting paid, and she only had one check left in that checkbook. I was going to pay her bills with her. So we went and closed the account. I had told Lisa we were at her house that Saturday prior to going to First Source Bank, and I told her that I would be helping her pay her bills.
Your mother, that is. You'd be helping your mother pay her bills?
Yeah, I told Lisa. My mom was with me. We were at her house.
Okay. But at no point did you berate her?
No.
Over the phone? At no point did you scream at her?
No, I was in a public place. The first times at First Source Bank, I was standing with my mom and a bank teller. The second time was in my mom's car on speakerphone. that she yelled at me and put my mom into a lot of panic and duress. And then the third time, I was at Best Buy and with my son, and she called me and yelled at me there as well.
You put her on speakerphone then too?
So.
Has the dynamic between you and your sister always been difficult?
It's been patchy. There's an instance before that she brought up in this where even the policeman told them to stay away from me because I went to her house to try to amend fences. As soon as I pulled in the driveway, they called the police on me and chased me out of the driveway, telling me not to leave, that the police were coming. So I went to the police department, and the policeman questioned my brother-in-law and then scolded my brother-in-law, got off the phone. He said, typically when people are scared of you, they don't say, stay here, do not leave. I had no intentions of doing anything that day other than trying to patch up, and make amends with her. She seemed to be very upset. I was going through a divorce and she was trying to help my ex-wife.
She was helping my ex-wife.
All right, so we have a couple of text messages here where you said you called her a narcissist.
Yes.
What was your thinking behind that?
She's been saying that I'm bipolar for years, and I've even talked to my therapist and told him about her, telling me that I was bipolar, and he said you're far from that. But she continues to tell my mom and my kids and everybody that I'm bipolar, and her daughter. I have witnessed that her daughter was telling my mom that I'm bipolar on the 25th, and she did not know there was someone upstairs. And she was saying things about me, and I stopped communication with her at that time. The only communication I had with her after the 24th, I did send her some mean text telling her to get a job in life.
Why'd you say that?
It was based off the fact we had a friendly conversation. I was in North Carolina where her son lives.
Hey, shout out North Carolina.
Passover Reservoir. Anyway, it was a nice conversation. Then we started talking about her parents, and she said my mom was a level 4 dementia, and that she needed to have her evaluated and put in a memory care facility. And I said I didn't want that, and she was fine where she was. And she goes, you act like I have no control. And she did have control. And then we went back and forth on that, and it was not yelling or anything like that. It was a debate, I guess, a healthy debate. And
healthy debate. You're a narcissist.
She said
You're bipolar.
the only reason I don't want my mom in a memory care facility is because I benefit from living with her. And I said, if that's the way you feel, we have nothing else to discuss. She hung up on me immediately. I sent those texts on talk to text while I was driving, and I regret sending them. They weren't
childish.
Friendly tone. They were very childish.
Okay, brother and sisterly love at its worst, right?
Yeah.
Okay. Same thing with why don't you get a job, correct?
She has way too much time on her hands to do this, and I feel because she's creating a lot of duress on our family, and it does not need to be this ugly. We should be working together and not against each other like we are.
This isn't the worst you guys have ever argued, though, is it? Have you guys ever argued worse than this kind of thing? Or is it the worst it's ever been? Between all of your guys'...
This is probably the worst it's ever been. I mean, we've had arguments, but I can't really remember anything this bad, other than the first time she did a PPO on me or whatever, or attempted, because, I did absolutely nothing. We had a weird conversation on the phone where she started yelling like she was talking to somebody else.
I think they're here to have the judge.
And then I went to her house because it seemed weird, and I didn't want any bad blood between us, and she called the police on me.
Coordinate Thanksgiving dinner.
Okay. That case was dismissed?
It was.
Voluntarily by her?
Yes.
Nothing came of it?
No.
All right. Why do you think your sister filed this PO against you? Do you think it was because she genuinely feels scared?
No. If she's scared because of what she's doing.
What do you mean?
She's been very manipulative. She's been hiding stuff from my mom. I'm with my mom quite a bit. She's asking to see her bank. And then my sister had all of my mom's mail forwarded to her house. That upset my mom immediately. She liked to at least see her mail. She wanted help. She'd been married for 30 years. She did not take care of her finances.
This is your mother you're talking about?
My mom, yeah. And my stepdad took care of all the finances, so this was all new to her. My sister, as far as I know, was only the POA from mid-December. They wrote in like the will or whatever that if the time came that they needed a POA, it would be Lisa, or a guardian, it would be Lisa. But she had never acted, as far as I know, as a POA until mid-December or beginning of December. She says 2019. I think that was what they wrote in the will. I don't think she was ever a POA. I could be wrong, I'm not sure about that. But once she became POA, she didn't discuss any of this stuff with my mom. She was not helping her.
I'm gonna get rid of that squeal.
Also,
so Larry, we're getting a little bit sidetracked, and but it happens. It happens. Focusing in on why do you think she filed this if she wasn't scared?
I think she wanted to do a PPO and then a guardianship, get me kicked out of the house and have full control.
Thank you. Pass the witness.
They're all still in the house? Everyone lives in the house together? It's a terrible image, but I'm sort of caught up in the story. I want to know how Thanksgiving dinner is going to go this year for the family.
I do. So does my sister.
All right. Thank you. And was there a PPO taken out against you by, is it your ex-wife?
Objection, relevance?
Prior PPOs and relevance?
Yes, this court here said that that would never show up on my record, this exact court that we're in, because I also had a notarized letter from Jessica stating that it didn't happen. So,
but there was
I don't know how that.
But there was a PPO entered at one point, correct?
Yes, during my divorce. Yeah, my attorney told me it was more common than not.
Hello. You've got mail.
You mentioned that you believe that that Ms. Lemke's motivation in obtaining this PPO is, and I apologize if I'm mischaracterizing your testimony, that it's to isolate your mother in a sense, to get her to control, in order to control her?
Yeah,
is that
what she wants to control?
Okay. And you have since been named power of attorney for your mother, correct?
No.
At one point, were you ever named power of attorney for your mother?
No, I didn't even want it. I didn't know if I could with this PPO on me. She named my son just so she could have some help at the bank.
Okay. Have you ever made any cash withdrawals from your mother's accounts?
No, we did once when my sister didn't pay her PNC bill. And my mom.
I'm going to object on this grounds for irrelevance too. What are we doing here?
Yeah, I mean, and again, I'm looking more at what the issues were dealing with threats and things of that nature, instead of getting into the particulars of, you know, the personal protection order or the finances of the parties. That's going to be handled by a different court. So.
Okay. He just testified about her motives, and I was trying to counteract that.
I have a general idea on what it is about.
I'll withdraw. In that case, Your Honor, I think I'll pass the witness.
No further questions.
I just ordered my Legos.
Do you have any further items to present?
Rest.
The rest.
Any rebuttal?
One moment.
Ordered some Legos. We're going to do a Lego live stream with Valhalla Awaits on Saturday evening. I'll be live streaming on this channel. So it's going to be dual streamed.
No, you're not.
All right. Argument then, counsel. Attorney Anderson.
As the court has identified, this is a dispute, a family dispute, and I don't think anyone would disagree on that. The mandates of the PPO statute on stalking and harassment are rather clear. this doesn't have to be a protracted or multitude of text messages. There just has to be more than one occasion of them that the text messages or the, I guess, cyber stalking has to be intended to cause emotional distress. It has to cause emotional distress, and it has to be unwelcome. Those are the mandates under the statute, Judge. In this case, those text messages were sent with the idea and the motivation that my client would cause emotional distress with the clear intent that she back down, back away, get out of this situation, get out of these finances, so that Mr. Lemke could take over and come in and, I guess, manage the finances in a way that he felt were best. But the idea being that she needs to, I guess, vacate this position. Whatever the merits of that may be are to be decided in another court, as this court has pointed out, and that's fine. Problem is that you can't achieve that through communications that are meant to intimidate or cause emotional distress. In Indiana, where those other cases are pending, we have witness intimidation statutes for that. But my client wanted to get a PPO because these text messages were of a nature that were causing her emotional distress, that was their intent, that Mr. Lemke, despite his testimony, does have a history of personal protection orders against him, that he does possess firearms. These all check the boxes under the statute for a non-domestic PPO. And for those reasons, PPO should issue in this case with the caveat that my client be able to transport her mother to a doctor's appointment on April 29th. Thank you.
Well, has there been any determination that she's not competent at this point in time?
Your Honor, that's a loaded question.
Well, I mean, the issue that I have, of course, with personal protection order, I don't think I have any authority to say who can transport who, where, when, why. It just becomes, if there's not a guardianship or conservatorship in place, if there's been a determination, I don't know if I have the authority to say she can transport, he can transport, she can go by herself, she can take a bus or a taxi. I don't think I have any authority to do that.
I agree, and I apologize for lack of clarity on my end. That's not what I'm asking the court. The foreseeable problem to me is that there's a buffer, and I need that buffer removed so that she can retrieve her money.
If I continue the personal protection order, that she had that ability.
Right, or that the PPO be waived for the strict purpose that she be able to pick up, because the mother and Mr. Lemke are living together at the moment. And so for her to pick up her mother, that puts Mr. Lemke in an untenable position of, well, does he help transport her out to the car? Does she have to go into the house to get her? There is an inevitability of contact here.
And I guess my practical problem is if there's not some order in place, I think she can make that choice. Does she have her son take her? Does she have her daughter take her?
Sure.
Does she take herself?
Right. Well, I'm operating from the presumption that the PPO would continue, obviously. So that was my concern. Honestly, if there's no PPO, then they're going to have to work it out. But this is just if the PPO continues. So that's the only reason I'm asking. Thank you.
Attorney Brad.
Thank you, Your Honor. I would address this multi-pronged. One, was this unconsented contact? Two, has the burden of proof been met? And then three, does a reasonable person really believe that these communications would cause somebody emotional distress? For that, I would just say this is a brother and sister, right? You can't ignore this context of brother and sister. This isn't a romantic relationship. They grew up together in the same house all their lives. They're basically both acting like children, as the testimony has shown. She's calling him names, he's calling her names.
This is his lawyer.
Just last night, having to look at my own children and tell them to be quiet as they were calling each other names. This does not raise to the point of unconsented contact between siblings, because it's just built into the dynamic. If we have name calling becoming the basis for harassment, I dare say every Thanksgiving you're going to get a plethora of filings for PO because dinner did not go very well, and one called one person a name and another one called another a name. It doesn't matter. You're brother and sister sitting in the same table, and you have parents. So I'm going to argue to you, Your Honor, this doesn't rise to that level. If it was intimate, if they were husband and wife, boyfriend and girlfriend, domestic relationship, Maybe, but narcissist? The best we have here is he called her a narcissist in a text message, and he testified that she called him a bipolar. And then you see in the text message under Exhibit A where it says aw with emoji after he says happy birthday, and she says thank you immediately after he calls her a narcissist. I'm sorry, but this is built into the relationship of brother and sister. I don't see this as unconsented contact. If it was unconsented contact, then given the dynamic, there should have been a letter or some sort of blatant statement of saying, don't bother me again. We're done. At that point, then you're on notice. But given the dynamic of brother and sister, without that kind of notice, we called each other names. I call my sister names, she calls me names.
What names?
It's just part of the dynamic. That being said, the next piece is the burden of proof. Can you really say that she has met her burden of preponderance of evidence that this is harassment when the evidence is showing that both are doing it to one another? It's consented contact for that reason. And then lastly, would a reasonable person find this to be harassment because of emotional distress? I don't see anything within these communications or hear anything within this testimony that would have risen to the level that a reasonable person under the same circumstances, such as yourself, myself, would have found that this would cause us emotional distress. And that's the standard. Not only what does the communication have to be intended to cause emotional distress, not only does it have to cause a person emotional distress, but we as objective observers of the situation have to also believe that a reasonable person would be caused emotional distress. I'm going to beat you up is something that a reasonable person is going to look at and say, that's going to cause me emotional distress. He's much bigger than her. He is actually making a physical threat. Yes, that would cause a reasonable person distress if they ever said they're going to physically hurt them, even though they never made that actual attempt. But you're a narcissist, followed with happy birthday, aw, thank you? No, that isn't going to cause somebody emotional distress or rise up to that level. I don't see anything in these communications that does any of that. And for these reasons, Your Honor, I think that you can conclude of your own behalf that this is really about the $10 million at the end of the day regarding their mother.
10 million?
I can tell you that she's been evaluated. That's as far as I'm willing to go with it, given the facts and evidence and the objections that would come otherwise. It's going to be up to the mother in the end. But I just don't see, I think that this all comes down to what's going on with the mother and the money established there. For these reasons, I would ask that the PO be denied. Mr. Lemke has given a warning to this court. If you didn't know before, Mr. Lemke, you do know it now. Your sister does not want any contact with you. If she files this again with evidence, substantiated that you're communicating with her in this kind of manner, I'm going to issue it. But for right now, here's your warning. No more communication. Thank you.
Any additional argument?
No, thank you.
Based on the proofs that I've heard here this morning, I'm gonna terminate the personal protection order. I do find there's a strained relationship here between a brother and a sister, and obviously does have issues to do with what we're not here today on the finances of the mother. I think those are issues that are going to be handled by another court in a guardianship conservatorship proceeding down in Indiana. That'll be washed out. I do read the text. There are some issues in here. He indicates she's called him bipolar. He's called her a narcissist. I don't see anything here that is physically threatening in any way, and I'm not convinced as well that it's meant to be something that's threatening or emotionally threatening to her. So I'm going to terminate the personal protection order based on the proofs that have been presented here today. And again, I think, Mr. Lemke, you heard it from your attorney, but from me, obviously, there's a relationship here. I think if there's some proceedings down in Indiana, that you let those any contacts that come up be in the course of those kind of proceedings. And my hope is, as a brother and sister, that hopefully down the road you can iron some things out, but that's going to be something that's going to be between you two. So we'll go ahead and just, again, you're free to read the petition if he were to continue to harass you or bother you or threaten you in any way. And she's free. So realize that if you do get into these kind of heated discussions or there are threats made, Those are all things that the court will take into consideration in addition to the evidence that's already been submitted here in the past, all right? With that then, counsel will go ahead and, anything further, Attorney Hanson?
No, Your Honor, I appreciate it. Of course,
Nothing further.
We'll go ahead and
Okay, so he said I'm going to terminate the PPO. There's no personal protection order.
Next matter, court will call, it's file 93-07815FH.
We're going to jump to Judge Dad.
Keith Nathaniel Thurston, that's in a motion.
Summary have to be filed and heard, not later than,
$10
20 days
million.
before the trial date. So
$10 million.
Your Honor, I think you said July 10th.
Yes, I'm sorry, July 15th, thank you. We've got a good staff here, they correct all my errors. July 15th at 10 a.m., we'll send this out, and that should be it for you. Anything else, counsel?
Nothing further, Mr. Hazy. You can just contact our office or have Beyond Finance call us.
Okay, thank you.
Have a good day, everybody. Thank you very much.
Thank you, Your Honor.
Jefferson Capital versus Andrew Smith, 2401159.
Good morning, Your Honor. Maxwell Quinn, P86016 for plaintiff.
Is Mr. Smith here, Linda? Andrew Smith?
I don't believe I had Mr. Smith check in.
And that was scheduled for 10:15. He was given 15 minutes. It's 10:52. You can go ahead and take your default judgment.
No, Your Honor, this is a defendant's objection to garnishment. They filed, looks like there's counsel on the other side. Their objection to a tax garnishment because, they're saying that there was an installment payment in order. However, according to the court rules, it doesn't preclude us from filing a.
Of course not.
Right. So that
the lawyer Sean Boyd own her, or Stephen Smith rather.
I have not heard anything from him.
Is Stephen Smith the lawyer here, Linda?
That's what it's looking like, but let me check in the file.
Let's jump down to a judge we haven't seen in a long time. How about that? Because they're taking forever. Y'all remember Judge Wolf, right? Here we are. He's not in the Heavenly Wood courtroom. He's in another court now. Just waiting for a little audio to kick in, though.
I have gone over this matter with Mr. Slade, and he wishes to admit that he violated the probation and have a hearing regarding the disposition.
Mr. Slade, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm to testify your best to give me the truth, all truth, and nothing but the truth, so help you God?
Yes, ma'am.
State your full name for the record.
Mr. Slade.
Mr. Slade, you're here today charged with violation of probation. It's been indicated you want to enter a plea of guilty to that charge. You understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation.
Yes.
You understand that if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with a public defender. Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that by pleading guilty to the charge, you're waiving your right to contest the issue of whether you did or did not violate your probation. Yes. Then we'll have a hearing for me to determine what should be done about your violation. In other words, I will make a decision whether or not to revoke you to serve your sentence or to give some alternative sentencing as may be suggested. But you understand that even if we have that hearing, you will be able to appeal, if you choose to, whatever I do about your violation.
Yes.
You're waiving your right to contest whether you violated, but you're reserving the right to appeal whatever I do in your case. Do you understand that?
Yes.
All right. You understand everything I've explained to you?
Yes.
How do you wish to plead to the charge of violation of probation?
Yes.
All right. Show that he has pled guilty to that, and I will find him guilty of that. We'll now move to the sentencing portion of that.
But we're going to move
again. Does the state wish to put on proof first?
Sure, Your Honor.
All right.
We want to hear what
Slade, have a seat.
Little proof. We're going to jump to Judge Webster in just a second because Mr. Gear is there.
Do you solemnly swear or affirm the testimony you're about to give me the truth, whole truth, and nothing but the truth, so help you God? I do. For the record, you're Jenny Donnelly, is that correct?
Correct.
And do you work with probation here in Houston County?
Correct. I currently work for the Cumberland Misdemeanor Probation.
Okay, and is Mr. Slade part of your caseload?
Yes, he is.
Okay, and when did he come to be on probation with you?
On April 24th of 2023.
Okay, and how long was his period of probation to be?
11 months, 29 days times 2.
Does that mean concurrent or consecutive?
Consecutive.
Okay. So 2 years essentially?
Correct.
Okay. And tell the court, what was he on probation for?
He was on probation for a simple possession of a Schedule 2 and reckless endangerment.
Okay. Tell the court how his, I guess, performance or cooperation on probation was.
Mr. Sled reported up until June of 2023, and while reporting 3 separate occasions, Mr. Sled tested positive for methamphetamines and heroin on 6/5, meth on 6/12, methamphetamines, fentanyl, and alcohol on 6/14, and absconded or failed to report on 6/21.
So you have not seen Mr. Sled reporting since 6/21?
Correct.
And do you think that he would be a good candidate to be released back on probation?
I believe that if he is to be released back on probation, it would be after a furlough or some form of treatment.
Treatment?
Correct.
Okay.
And is Mr. Sled in the courtroom today?
Everyone buckle up.
All right. He's sitting with his attorney.
Yes, he is.
We're going to Judge Webster.
Right, because it's in the afternoon. It's different than we usually do.
Yes, ma'am.
All right, thank you. You may go, sir.
And Your Honor, just to be clear, that May 28, 1:30 date, that is all 3 cases?
That is all 3 cases. Yes, thank you.
Thank you, Your Honor.
This is
Now
men's
let's
court.
You're welcome. Let's go back to Mr. Romero.
Men's court. No women, just men, except for Judge Webster.
Back on the record in 2023 TR 565, State of Kansas versus Antonio Romero, who is present in person with counsel Nathan Geffrey, as is Jared Regier for the state. And this was a question that the defendant wanted to speak to his attorney before answering a question of whether he stipulated to violating his diversion or whether he wanted an evidentiary hearing. Mr. Geffrey, at this time?
Stipulate, Your Honor.
All right, so just hear it from you personally, Mr. Romero. You've had time to talk to your attorney?
Yes.
And you do at this time waive your right to hearing and stipulate, that is, agree that you violated your diversion as alleged?
Yes.
All right, is anyone making you waive your hearing and stipulate to violations?
Negative.
Okay. Then I will find that you have knowingly and voluntarily waived your right to hearing and stipulated to the violations. Finding the defendant in violation of diversion, specifically that he did not pay as agreed, he did not successfully complete a 48-hour alcohol and drug safety action program, and that he did not provide proof of completing outpatient level 1 treatment. The defendant is revoked on probation. The next matter of business, the diversion agreement does contain a stipulation to the facts, specifically that if the diversion is revoked for any reason, the matter will go to trial on facts stipulated to in the diversion agreement. And that stipulation of facts includes evidence consisting of the entire contents of the reports submitted by Kansas Highway Patrol G in their case number 2023-001261, including any affidavits, written statements,
All
or
right, Judge
narrative
Webster.
reports prepared by law enforcement.
It was nice to visit you. We're going to jump again. We've got a
With
jury
the facts
selection
being
just done.
stipulated to as summarized in count 1. But on February 4th, 2023,
let's see.
Defendant did operate a motor vehicle.
First, going to place you under oath about the questions you're about to be asked.
Do you solemnly swear or
We're
affirm
trying
that
to
you will
catch
answer
up.
truthfully all questions asked of you as prospective jurors, so help you God?
Thank you. All right, ladies and gentlemen, just for the record, I think the first couple of names I called, we did not get the juror numbers on the record, so I want that to be clear that Miss Bush is juror number 136, and Miss Below, how do you say that again, man? Vayu. I'm going to get it wrong. I apologize in advance. I'll try to write
Mercer
it.
just sat a jury for a case. We're going to
I can say that.
for a little bit.
Vayu. That's exactly what I did. Miss Vayu is number 140. Okay, so ladies and gentlemen, we're going to ask you some questions. And keep in mind, these questions may or may not be intrusive. You may find them intrusive. You may not. It's a personal preference. But the purpose of the questions is to provide a fair juror for both the state and the defense. Let me give an example. If you had supper last night at Mr. Mitchell's house or Mr. McDaniel's house, you're not going to be on this jury. That's just probably what's going to happen. So we have to find jurors or attempt to find jurors that don't know anything about the case or know nothing, very little about the case, and that can be fair and impartial, and that they don't have anything in their past that would make them, you may be a great juror in some cases, but you may not be the perfect juror for this case. So that's the purpose of these questions. The first person in each row should have this. Did you have that? So what we're going to do is, this is a list of questions. I'm going to read these questions so that they'll be on our record, and then we're going to pass that list down and ask that you answer the questions. The reason we do that is it kind of speeds up the process. The first 11 questions are exactly the same for all of you. Once we get through those questions, then the attorneys will choose additional questions that they think are important and ask you those questions. So the list of questions are these. Number 1, your name. Number 2, the town or city you live in, not your street address. This is open to the public. We are on the internet. Not put your street address on there or say that. If someone says, it says the town or city you live in, when you read that, it's Greenwood, Mariana, Grand Ridge, whatever it is. Number 3 is your occupation. If retired, your former occupation. Question number 4 is your marital status. Question number 5, your spouse's occupation if you're married, and their former occupation if they're retired, divorced, or if they're deceased. Number 6, the number of children and their occupations if employed.
Hey, Jackie.
So if you have adult children, their occupations is what that's talking about. Number 7, do you have prior criminal service, and was it criminal or civil? You're not asked the result of that verdict, but you are asked if you had prior service and whether it was criminal or civil. Question number 8 is, are you a party in a pending or past lawsuit, and whether it was civil or criminal? Question number 9 is, do you know anyone in the courtroom? That includes other jurors, the attorneys, and so forth. Number 10, have you had any experience with the state attorney's office or law enforcement agency that would influence your decision? And number 11, can and will you be a fair and impartial juror and base your decision solely upon the evidence and the law? Those are the questions each of you are asked to answer, and we'll start with Ms. Bush. You don't have to say the question, just kind of go through the list, if you will.
Okay, let's see what the time is.
Single, not married, 1 child, no jury service or experience, no opinion of past lawsuits. Yes, I do know someone in the courtroom. No experience with the state attorney's office or law enforcement agency. And yes, I can will be a fair and impartial jury based on my decision.
Thank you. 2 follow-up questions, Ms. Bush. Paraprofessional, a lot of people mean, when I was in school, it was called teacher's aide. Is that what you mean? Same type of thing, you're assisting the education process. And the last question is, do you know anyone in the courtroom? The reason for that question is to make sure there's no relationships. We don't want 2 people on the jury, or it's 1 person on the jury that knows someone that's going to affect their fairness and impartiality. So who do you know in the courtroom? Ms. Gilly, and what's that nature of that relationship? Okay. The attorneys may ask some follow-up questions with that. Okay. Thank you. If you'll pass a list down to Ms. Bayou.
My husband's retired. I have 1 child. No jury service prior. And past lawsuits. I do not know anybody in the courtroom. I've had 0 experience with state attorney's office, and I can be fair and respectfully fair and impartial based on my decisions solely upon the evidence.
Thank you, Ms. Bayou. What line of work is your husband retired from?
He was a asphalt plant operator.
Thank you. And we have Ms. Gillespie.
Yes, my name is Donna. I live in Baltimore, Florida. I'm married. My husband. Okay. No.
Okay, I'm going to mute them for just a minute. I'll read you the background as they're talking about to the jurors. In this case, we've got a white male who suspiciously parked the vehicle in the Florida Caverns RV Resort located on Highway 90 and left walking. A short time later, witness heard an alarm going off at a nearby pawn shop, and they arrested Michael Thomas McKira, 33 years of age, resident of Bonifay. The charges are burglary of unoccupied structure or conveyance, possession of burglary tools, and possession with intent to use those said burglary tools. That's this case.
Thank you, Ms. Gillespie. Are your 4 children, are any of them employed?
I think I'm going to fast forward because we're half an hour behind. I want to fast forward through some of this jury selection to see if we can get, I think it's actually just jury selection today. Is it trial today, Josh? Do you know? Or is it just jury selection? Trial set for Thursday. Oh, you already told me. So we'll stick through this. Burglary tools could be a hammer, a screwdriver, lockpick set.
Thank you. And we have Miss Gilly.
Some jiggler keys.
My name is Donna Gilly. I live in Seeds, Florida. My occupation is bookkeeper secretary for a school. Marital status, divorce. I have 2 children, and one is in human resources at Florida State Hospital, and one is with Jackson County Health Department. I have no prior jury service. I have not been a party in a pending lawsuit, a past lawsuit. I do know one person in the courtroom. I have not had any experience with the state attorney's office or law enforcement agency, and I will be a fair and impartial judge.
Thank you, Ms. Gilly. When that door opens, you hear the vacuum cleaner noise. When we got here this morning, the clerk's office was in how much water? 2 inches of water. So they had some kind of air conditioning. So I apologize for the noise. And if it gets to be a problem, someone let me know. But as long as the door's shut, it seems to be manageable. But if it begins to bother you, let me know. So that's what that noise is. Ms. Davis.
Judge, if I can just get them to let them know that they're speaking to the gentleman back over here.
Thank you. So the only microphone in that jury box is over there on the left side. So everyone please speak up, especially if you're on the right side of the box, so that everybody on the other side of the court. And the way I do it is I pretend that I'm talking to the gentleman over here in the first row, pretend that you're talking to the furthest person in the room. And if you're talking to that person, everybody between you and them will hear you. So if you'd please start over, Ms. Davis.
My name is Bianca Davis. My town and city is Marietta, Florida. My occupation, I'm a nurse. My marital status, engaged. Occupation, just left the military. Number of children, 1, 8. Prior jury service, criminal or civil, none. Party in any pending or past lawsuit, criminal or civil. No. Do you know anyone in the courtroom? No. Have you had any experience with the state attorney's office or law enforcement agency? No. Can we be a fair and impartial juror and base your decision solely upon the evidence and the law? Yes, sir.
Thank you, Ms. Davis. And is it Ms. Rowley?
My name's Delilah Raleigh. Currently moved to Cypress, Florida. I don't live in Cottondale anymore, but I still live in Jackson County. So I just haven't changed it. I work as a cashier. I'm widowed. He was a meat cutter. I have no children of my own. No prior jury service. No lawsuits pending or past. I know nobody in the courtroom, and I've had no experience with the state attorneys or law enforcement agency. And I will be a fair and impartial juror based on my own.
Thank you. We'll get that list from you in just a few minutes. Mr. Addison.
Derek Addison. I live in Graceville, Florida. I'm a pipe fitter, divorced. I've got 2 children, no prior jury service. Don't have any lawsuits. Don't know anybody in the courtroom. I've had no experience with the state attorney's office or law enforcement agencies, and I can and will be a fair and impartial juror based on decisions solely upon the evidence and the law.
Thank you, Mr. Addison. Mr. Kaufman.
Named Robert Kaufman, Mariana, I'm a store clerk. I'm divorced. Spouse. I have one 15-year-old child. I have no prior jury service, criminal or civil. I have no pending lawsuits, criminal or civil. I'm waiting in the courtroom. I've experienced in the attorney's office for law enforcement. I will be a fair and impartial juror based on my decision.
Thank you, Mr. Kaufman. And Ms. Bess, better known as Gabby.
My name is Gabrielle Bess. I live in Mariana. I am a nurse. I'm single. Spouse. I don't have any children. No prior jury service. I'm not a party of any pending or past lawsuits. I do know somebody in the courtroom. I've not had any experience with the state attorney's office.
Who do you know?
And I will be a fair and impartial.
Thank you. The person you know is me or anyone besides me? Okay. So Miss Bess and my daughter played volleyball together, and she is the niece of our deputy court administrator. She's super smart and a fairly recent graduate of nursing school, correct? Thank you. And Miss Bryant.
Yeah, she's gone. She's gone.
I live in Greenwood, Florida. My occupation, I are disabled and plus I work part-time in cleaners and open. I am married. My husband is disabled. I got 2 children. One works for a medical company online from home, and the other one is partially going to school and doing something online.
He's doing something online. He's playing Call of Duty online while he's supposed to be going to school.
I don't have a lawsuit, and I do not know here, and I have nothing to do with state and I can't get there.
Thank you very much, Ms. Bryant and Ms. Patterson.
My name is Patricia Patterson. I live in Mariana, Florida. I'm a speech language pathologist. I'm married. My spouse is a contractor. I have one child. She's a nurse. I have no prior jury service. No pending lawsuits. Don't know anyone in the courtroom. I don't have any experience with anyone in the state attorney's office, and I can be a fair and impartial juror.
Thank you, Ms. Patterson. Ms. Stone.
My name is Sherry Stone. I live in Mariana, Florida. I'm disabled. I am married. I have 3 children. One works for a health company. One works as a supervisor for construction, and the other one works for the same construction. I have no prior jury service. I'm not a party to any pending or past lawsuit. I don't know anyone in the courtroom. I have no experience with the state attorney's office or law enforcement, and I can be a fair and
Thank you, Ms. Stone. And then we have Ms. Couch.
My name is Cheyenne Couch. I live in Greenwood. I'm not employed. I'm not married. Have no children, no prior jury service. I'm not a party in any pending or past lawsuit. I don't know anyone in the courtroom. I've had no experience with state attorney's office or law enforcement agency, and I can and will be a fair and impartial.
Thank you, Ms. Couch. And we have Ms. Pittman.
My name is Sandra Pittman. I'm from Bascom, Florida. I am retired from the Florida Department of Corrections. My marital status is married. My spouse also worked for the Florida Department of Corrections and retired from security.
Yes, she gone.
Number of children, we have one adult daughter. She's a physical therapist. Prior jury experience, did serve on a criminal case probably 35 or so years ago where a verdict was reached. I am not involved in any pending or past lawsuit. I do know one person in the courtroom. I have not had any experience with a state attorney's office or law enforcement agency that would influence my decision. And I can and will serve as a fair and impartial juror.
Thank you. Ms. Pittman, the person you know, is it someone on the jury or someone else?
Someone, it's Mr. Dunaway. We work together at corrections.
He's also from the Bascom area too, I believe. All right. So Deputy Dunaway is not a witness. He's here as filling in because we have a deputy out. Gentlemen, he's not a witness, correct?
He's not a witness, no.
He's a supervisor now. He doesn't even usually talk to us, Ms. Pittman, but we have a bailiff out today. So Deputy Dunaway, actually a Sergeant Dunaway now. Sergeant Dunaway is filling in. So we're glad to have him here. Thank you. And Miss, can't read my own handwriting. It looks like Banahan.
It's Mary Banahan. I live in Greenwood. I'm retired and I work for Sunland. I'm married. My husband is retired, disabled from, he was a sergeant at Department of Corrections. I have 2 children. One, she works for a trucking company and the second one's deceased. Prior jury service, no. No lawsuits. I don't know anyone in the courtroom. And I've never had any, problems with the state attorney or law enforcement, and I can be a fair.
Thank you very much. Miss Milligan.
My name is Stephanie Milligan, Campbellton, Florida. I'm a nurse and self-employed. I own my own business. I'm married. My husband is in business with me, and he also is a supervisor for a clearing company.
I'm sorry, for what kind of company?
Clearing.
Okay.
No kids, no prior jury service. Not a party in any pending or past lawsuit. I don't know anyone in the courtroom, and I have no experience with the state attorney's office or law enforcement agency, and I can and will be a fair and impartial juror.
Thank you. Mr. Edenfield.
My name is Sean Edfield. I'm from Cottondale, Florida. Occupation is solar technician. I'm married. My wife is a homemaker. I have 2 kids. I have no prior jury experience. I'm not a party in a pending or past lawsuit. I do know somebody in the courtroom. I haven't had no experience with the state attorney's office, law enforcement agency that will close my decision. I will be a fair and impartial juror based on my decision solely upon the evidence and law.
Thank you, Mr. Edenfield. Who's a person you know in the courtroom?
Miss Donna Green.
Okay.
She was my old elementary high school teacher.
Miss who? Miss Gilly? Miss Gilly, okay.
Miss Gilly doesn't remember him, but.
Who'd you say it was? Miss Gilly? She doesn't even remember that. Now, where was that at? What school? Sneed Elementary.
She was my elementary.
A while ago, huh?
She's like, I don't remember you at all.
She ain't seen me in 20 years. Something like that.
Thank you,
teacher
Mr.
ever.
Eric.
I don't know who you are.
My name is Fort Wayne Eric. I live in Mariana. I am a teacher. I'm married. My wife is county extension director for the county.
I talk quietly.
I have 1 child who's 38, a teacher in Alabama. And no prior jury service. I'm not a party for any lawsuit. I do not know anyone in the courtroom. I do not have any experience with the state attorney's office, law enforcement agency that influence my decision. And I can be fair and impartial juror based on decisions solely upon evidence and law.
Thank you, Mr. Eric. What subject do you teach?
Work history.
Thank you.
Constitutional law.
Okay, so we'll take up those placards from you, ladies and gentlemen. Now the attorneys have the right to ask you a few questions. They'll ask you questions that are more specific to this particular case. You learn a little bit about the case, and then we'll go from there. The state goes first. And Mr. Mitchell, any questions for the prospective jurors? Do you need the podium, Mr. Mitchell? You already got it set up, don't you?
Yeah, I'm good on that.
Thank you.
Please support, counsel.
Okay. Lawyers get to ask a few questions here.
It's a very top-heavy podium, everybody. All right. Good morning, ladies and gentlemen. Like the judge said, my name is Jake Mitchell, and I represent the people of the state of Florida in the state attorney's office. Now, I'm not joined today by who will be sitting second chair with me. They're currently in the other courtroom, but as the judge said, this case is on Thursday, and I will either have ASA Lawrence Gill or our Chief ASA Shayla Jeffcoat with me on that day. Before I continue, does anybody know or recognize those names? I'm seeing a lot of shaking heads. So, okay. So this process that you've heard of is what we call voir dire. And before I get into what voir dire is, let me just emphasize a more common term of what it's called, and that's jury selection. Now, I know jury selection in, the media has kind of a negative reputation. Everybody gets the slip. They go, oh God, I got to go sit in jury duty. And I know it gets that negative reputation, but it's important to note that jury duty is actually one of the more fundamental ways that you as a citizen can actually serve your country. The others are, being in the military, voting, and jury duties lumped into those right there. And there's a reason why it's considered a very important process. This process is important because you hold the state accountable. You make sure that the state meets their burden, which I'll get into a little bit on down the road. And you make sure that justice is done, that the laws are followed, and that the defendants in every case get their due process and get their day in court. So because of that, that's why jury duty, at least in my mind and many other people's mind, is considered an essential part of, being a citizen of this country. So we thank you for being here today, and we appreciate your patience, we appreciate your time and your attention. Now, voir dire is one of the only few moments in which myself and Mr. McDaniel, who is representing the defense today, will actually be able to speak to you. This is the more informal way because we get to actually ask each of you questions if we want to. We get to basically get to know each other a little bit better. Now, I understand that, some of y'all may not do as well as you think, getting cold called, or, may find it, oh God, he wants to embarrass me or something. That is not my goal. My goal is not to embarrass you or humiliate you in any way. My goal here is to ensure that, there's fairness among each and every single one of you. So, if I ask you a question and you don't feel comfortable answering it, just let me know. And if we need to, we can actually go up and speak silently to the judge regarding that question. Like I said, if you get a question or you feel like you need to tell me or Mr. McDaniel something, just raise your hand and we'll answer it. It's an informal process, but it's a very important process, and you'll see it's not so bad. Now, as a jury, what is your job? Your job as a jury is to be fair and impartial. That's one of the last questions that you had on those questionnaires that says you are to pay attention, listen to the evidence, decide the credibility and the factors of the testimony and the evidence presented. Then you will go into the jury room, talk about the evidence, and then come back with a unanimous verdict, all while being fair and impartial. There is to be no bias. There's to be no sympathy. There's to be no prejudice. And you will follow and base your decision strictly on the law and the evidence as presented. And I'll get into more of that a little bit later. Now, I made mention to it that it is your job to make sure that the state meets its burden. And that burden that we have to meet is one of the highest burdens in the criminal justice system. That burden is beyond a reasonable doubt. I'm sure everyone here has heard of beyond a reasonable doubt. It's one of the highest burdens that the state has to meet in any criminal case. And this standard remains the same, whether it be we are, trying to prove beyond a reasonable doubt that the defendant committed something like a petty theft or something all the way up to a capital murder. No matter what, that burden of doubt always remains the same. Now, Judge Mercer is going to instruct you on reasonable doubt as we sort of get towards the end of the trial. But for now, everybody kind of understands that, you know, whenever the words reasonable doubt are used, you're to consider the following: that a reasonable doubt is not a mere possible doubt. It's not a speculative doubt. It's not an imaginary doubt, or it's a forced doubt. Basically, what you're doing is you're thinking reasonably and using common sense. Like, everybody sees that I'm here today. How do you think I got into this courtroom today? Well, I walked in through the door.
Magic.
But I could have very just as easily come from that air vent, couldn't I?
Mm-hmm.
It's reasonable. But does it make sense? Is it, you know, reasonable, and is it common sense?
You said it was reasonable.
That's what the burden is that you're using right there.
It's possible, not reasonable.
Now, does everybody kind of understand what I mean when I say beyond a reasonable doubt? Seeing a lot of noddings. Okay, good, good. And is there anyone here who can't decide this case beyond a reasonable doubt? Is there anyone here that thinks, well, I need something exceptional, I need something concrete? I'm seeing no hands, so everybody understands that the burden is beyond a reasonable doubt. Okay, and it's through this burden that I have the task of proving to all of you today that on January 24th, 2025 of this year, the defendant, Michael Thomas McCara, committed the crime of battery. Now, I'm going to go into the elements right quick, but I'm going to go into the elements soon, not right quick, but let me get this done right quick. Battery. So there were a couple of questions that a few of you answered, and I am going to have to pick out a couple of you that I just wanted to address before I went into something more. Miss Davis, Deandra Davis. So I'm going to give you a little background on what, you know, our investigators and what usually happens whenever we get what's called a jury venire, which is a list of all the people that are going to be on the jury. What we do is we will usually run their history and see if they have anything. You answered that question on there that you said you had no prior experience. I only want, and I'm not trying to embarrass you or anything. I just want to make sure if this is a coincidence or something, because when your name was run, it actually showed that a woman by the name of Deandra Davis had a couple of priors from the year 2011, 2012, 2013, and 2014.
I thought that it might feel like if I was working for the department.
Okay, yeah. Okay, so that kind of clears it up, you know, like any prior experience with, and anybody else can pop in with this. So prior experience with the state attorney's office means, you know, I have gone to court before. I've been a defendant. I've been before a judge. You know, I've entered a plea before, or the case was dismissed. Was that kind of similar to what happened with you right there?
What the question on the form, so you may want to ask a more specific question if you wish. The question they're asked is, have you had any experience with the state attorney's office or a law enforcement agency that would have influenced your decision? So it doesn't matter if they had experience or not. If it wouldn't influence the decision, the answer to the question is no. Okay. So if that's not the question you want to ask, you may want to ask a different question. Because
I was going to ask that question at the end right there. So you don't deny that there was some priors that you had maybe in those years, but knowing that now, does that affect your ability to be fair and impartial in this case that you're about to hear today? It doesn't at all. Okay, that's all I wanted to ask. And let me see.
So the case I read, you might be a prior conviction.
You were the only one, so I guess I did kind of single you out a little bit, but I thank you for being honest with me.
Might be a prior or possibly a wrong person.
Like I said,
go.
The charge that you will be deciding here today is the crime of battery. So here are the elements of what a battery is. To prove the crime of battery, the state must prove the following elements beyond a reasonable doubt.
Does it have a positive or negative term?
Michael Thomas McCara actually and intentionally touched or struck the victim against her will, or here's the key part, or Michael Thomas McCara intentionally caused bodily harm to the victim. Now let's start with the element of intentionally touch or strike someone against their will. Let's go, since you have a popular last name, Miss Bayou. What do you think it means to, touch somebody?
Physical contact.
Make physical contact, like this podium right here. I'm touching it right there. Okay.
Inappropriate.
Anybody else have any other answer to that? What it means to touch somebody? I know it sounds like a silly question, but it's important that I put this out there so that each of you can understand. And that leads into the next question.
Great mods. Thank
Let's
you so much.
go, Miss Bess. How much contact does the touch require?
Just enough to form the spark.
You have no idea. What about brushing against somebody? Like you're walking, you just kind of brush against somebody right there. Would you consider that a touch or just kind of like something minor? Miss Brown, I see you kind of shaking your head. You kind of see it as that's not really a touch at that point. And that's kind of leading into what the next part is. We think of these slight contacts of touches and, maybe it's not intentionally touching someone against their will. Who here has been to a football game? Come on, raise your hands. Let me see who I can pick on.
No hands.
All right. Who here's a Florida State fan? Miss Bush, I'm picking on you. So you've been to a Florida State game in the past, haven't you? Well, not this past year, but let's say 2023, it was pretty crowded. It would get pretty crowded during those games. And, you would bump into people as you're kind of leaving and kind of getting into your seat. And, last year it was more, you were bumping into people as you were leaving at halftime. So, but, how did you feel when these people were bumping into you at these football games?
Oh,
it was just.
What's going on around.
He's picking on her and her team.
I'm glad you said that right there, take into the consideration, because, you don't think about this, but, if you're in a crowded area, like a football game, maybe the subway, anybody here ever taken the subway, like in New York or something?
Nope.
I see Miss Bayou is shaking her head. So you understand how crowded it can be. You understand I'm trying to think of the word. You understand the characteristics that if you go in there, you're probably going to bump into somebody. That actually introduces what's called implied consent. And in that situation, you understand the dangers. You understand that somebody's probably going to, bump into you and touch you while you're in there. But, you don't think nothing of it because you understand, the circumstances behind all that. So that's important to take into account. Now, do you think, people may bump into each other intentionally in these situations? It would be kind of harder to pick out whether or not you can see if they're actually and intentionally bumping into you in like the subway or a football game. Now, who here's seen The Sound of Music? Miss Bayou, you're very popular with all of my questions, but I'm going to go with Miss Gilly. So you've seen The Sound of Music, the song, The Hills Are Alive, when, oh God, I always get it's Julie Andrews, right? It's Julie Andrews, that's right. She runs through the field, through the valley, the hills are alive. And now just imagine from out of nowhere, she's singing this song, and here comes Dwayne The Rock Johnson from out of nowhere, and he just clotheslines her right there in the middle of the field.
Seems appropriate because you couldn't remember.
That would be intentional, wouldn't it? Nobody else is around. That is a touch that, well, she would not have implied consent for. So, strange example again, but everybody kind of understands what I mean when it's, the difference between intentionally touching and unintentionally touching. You see what I mean, correct?
That movie will never be the same for me.
Now, let's go with the act of touching / striking against your will. Let's go with Mr. Edenfield. You seem very happy to be put on the spot. So let's say you're walking down Highway 90, right there on those sidewalks, and Miss Milligan just comes up and just punches you. Very out of nowhere, isn't it? Has she touched you against your will? Did you invite that contact? So, but what if the punch doesn't leave a mark? And Miss Banahan, right? Miss Banahan, you said it's still a push, correct? So, everybody sees that, a push is a push, a touch is a touch. Sometimes it may not leave injury, sometimes it may. But everybody can see that, in this scenario, Miss Milligan still hit Mr. Edenfield against his will without his consent. Maybe it didn't leave a mark, maybe it did, but it's still a push. It's still a touch, correct? All right. Does it matter who touched you in that situation? Does it matter who pushed you? What if it was somebody like Shaquille O'Neal? He's a gigantic guy. What if it was somebody like Taylor Swift? She's kind of tall, but these people are she's not Shaquille O'Neal built or something. Doesn't matter in that situation because a push is a push. A touch is a touch. Everybody understands that, correct? Okay.
We've got The Rock.
Now, is there anybody here that does not agree with me in that situation?
And Swifties.
I don't see any hands, so everybody agrees
Terrible question.
on those facts. Okay. Miss Pittman, what do you think the difference is between a touch and a strike?
The level of force used.
The level of force used? Okay. Would you consider a strike to have more force? No, especially since touch, strike. You can kind of see that right there. So if you were at a football game, a bump, would it be against your will? Not really. But The Rock bumping into Julie Andrews, clotheslining her on the Valley Hills.
That's not a bump.
That's against her will, isn't it? Okay. Does everybody understand what I mean when I say against your will?
No.
Okay.
Not when you say it.
Now, Mr. Kaufman, do all batteries result in injuries? You would assume so. What if I were to tell you that, not every battery will result in leaving an injury or a mark? There could be redness, but there could be no lasting effects. Does that not make it a battery? It doesn't make it a battery.
Yeah, purple's out. He's gone.
So and this is what I want to point out why I asked that question, because the elements to prove a battery don't include the state needing to prove an injury. Remember when I was reading those elements and I read the first element and then I said, or? That's the key point. We're not required to prove an injury, but it's one of the things that can be proven. We can prove that the defendant touched or unlawfully touched the victim against her will or caused harm to the victim. So everybody understands that, the state doesn't have to prove an injury to prove a battery. Is there anyone up here that says, no, I need to see an injury to show that there's a battery? And you can raise your hands if anybody thinks that. All right. Let's see. So,
bailiffs are switching shifts.
Ms. Couch, you heard me point out about how batteries or touches can be minor, just like that. You heard me. All right.
The judge said, bring me my phone. I've got to play Candy Crush during this portion.
Well, let's say that it does leave an injury. Like somehow this leaves an injury. Does it have to be serious? Like, does it have to be a broken bone or can it be like a bruise or something? It doesn't have to be serious? Okay. Is there anyone up here that thinks I need to see a serious injury to consider a battery, or I need to see a bruise, I need to see a red mark or something along that line? Y'all are all understanding. I like that. All right, so let's go. Mr. Addison, are there any defenses to battery?
Any defenses?
Yeah, any defenses. Somebody comes up to you, strikes you. Do you have any defense?
Yeah, I'd say so.
Yeah, what would it be?
Shoot them.
I would guess, I'm not sure, to be honest with you.
Are you thinking somewhere along the lines of like self-defense? Okay. And so somebody hits you with their fist and you respond back by punching them. Does that seem like reasonable self-defense? What if somebody punches you and you pull out a knife or a gun? Does that seem reasonable? Okay. Has anybody up here ever had to defend themselves in a fight? I know that's kind of putting you on the spot. So Miss Milligan, right? So you've had to defend yourself in the past before? Do you mind sharing that experience? You don't have to share it in detail, just the gist of it. You were assaulted as a nurse. Okay. And what did you do in, I guess, retort or something?
I just tried to.
You just tried to kind of push them off. Okay. And that seemed reasonable. Okay. To you, it did. So like, if you just picked up like a bedpan or something and defended yourself that way, would that be reasonable?
If you knew what he was doing.
It depends on the circumstances. Okay, so everybody understands what reasonable self-defense means. Is there anyone here that does not or isn't getting what I mean when I say reasonable self-defense? Okay. So what factors go into play when determining reasonable self-defense, Miss Rowley? Fending off somebody that's attacking you. What about like the ability of the party, like, or the capacities? Yes. Or the one actually doing the attacking. I got you. Is there anybody here that does know how to kind of answer that? Nobody? Oh, man.
Maybe ask a better question.
So, Ms. Gilly, what are some factors that you take into account to determining whether or not it's reasonable self-defense or not?
Person size,
size,
age, reasons behind their attack.
I got you. Size, weight, it could give somebody a
who started it?
Advantage or a disadvantage in that situation. So, I've already mentioned about how, Mr. Addison gets into a fist fight or somebody punches him and somebody pulls a gun on him, or no, he pulls a gun on the person that just attacked him, Miss Gillespie. Is that reasonable? It all depends on the circumstances. Let's say the attacker doesn't have any weapons. What the attacker's intent is. Okay. All right. I'm glad you said that. So everybody understands that, it's what the attacker's intent and the circumstances is. Is there anybody up here who does not, understand or thinks differently when it comes to reasonable self-defense? Yes. Okay. All right. So you think it's reasonable to always defend yourself?
Yes.
Yep. And let's see. But you still understand that the reasonableness plays into the circumstances of what's going on. Okay. And, you say, let me try that again. So you believe that everybody has a reasonable right to defend themselves in any battery. So there may be a possibility of self-defense brought up in this case. Is knowing what you say about self-defense and what I have said and what everybody else has said, does your opinion on the matter, will it impair your ability to be fair and impartial and listen to the testimony and evidence that will be presented in this case?
Scratch all that.
Absolutely not. Okay.
I apologize.
I just wanted to ask and get that up on the record. All right. So let's talk about victims in a case. So we talked about, the self-defense. We talked about that. Miss Patterson, how would you expect a victim to act after they've been the victim of a violent crime?
Maybe cry a little bit. Call the police.
They would be emotional, wouldn't they? They would be pretty emotional. What else would you expect them to do? Like, what actions would they do after they've been the victim of a violent crime? Let's go with Miss Stone. They would call 911. Do you think that they would possibly run away? You think they would probably act in self-defense? Okay. There's a lot of different ways that each victim will act if they've been the victim of a violent crime. Now, let's go. Who have I not called on yet? I think I've kind of hit all of y'all. Ms. Banahan, let's go with you again. So what are some reasons that you think a victim would not report or would act contradictory to what Miss Patterson said?
Well, I would think that if they were frightened that it's going to happen again, or something worse would happen, say that threatened person might threaten their family or something to that effect.
So you think retaliation may be in the play, and this may scare them enough? Do you think that, the victim's mental state could play a factor in it? Okay. What about, just pride? And I say pride because there's sometimes people out there that will be victims of a violent crime, but they say, nah, I can handle it. I'm not doing anything about it.
I assume that could happen.
You assume that could happen. What about family pressure? Like, what if the victim gets hit, but the family is basically saying, no, don't take that to the police? That's another factor that could happen. Or, you have friends coming in and saying, no, don't cooperate. Don't say anything like that. And yet, despite all those factors, all the reasons why they may not cooperate or report the crime or call 911, does that still not make them a victim? They're still a victim. Okay, so is there anyone here that thinks, or is there anyone here that, heard my questioning, heard where, the victim,
your questioning was questionable.
Didn't cooperate, didn't call 911, didn't want to do anything with the charges. Is there anyone here who thinks that doesn't make them a victim? Y'all are very understanding. I appreciate that.
No, they don't understand your questions.
As I've said today, it is the state's job to prove this case beyond a reasonable doubt. It's our job to prove that Mr. McCara committed the crime of battery against the victim. And how we're going to do that is we're going to present evidence. Evidence in this case will consist of testimony of witnesses, pictures, videos. Is there anybody here that thinks they need more than just the testimony or a few pictures or a few clips? Does anybody think they need more?
More what?
So everybody understands that, you
More
know,
evidence before they
when
can
it
convict.
comes to presenting evidence, it's not about the quantity of the evidence, it's about the quality of the evidence. I could put 30 witnesses on the stand. I'm not going to do that to y'all, but I could put 30 witnesses on the stand. That doesn't mean that I've met my burden. It's all about what those 30 witnesses could say, the quality evidence over the quantity. Is there anybody that doesn't agree with that? Okay.
There's a nice pair of Converse shoes
You'll
in the
hear
top
the
right-hand
testimony from a couple of witnesses in this case. And one of the things that it's going to be your job to determine is to determine the credibility of each of those witnesses. Ms. Couch, what are some factors that you will look for in determining whether or not the witness is credible or not?
I mean, if they were under the influence of something.
If they were under the influence of something. Okay, yeah. What about if they remembered things inaccurately or they remembered things differently?
Yeah, if they like counted every time, like every time.
Okay. Miss Bryant, I think I heard you. My hearing is selective sometimes. It really is. So do you agree with me that, you know, memories fade over time? Do you think that they're able to be refreshed? And, you know, I'll give an example. So I was actually on a Mission Impossible marathon, watching all the movies left and right. I was watching it with my girlfriend and her mother.
Why am I not
and
surprised?
They kept going, is this the movie where Tom Cruise breaks his foot while doing a stunt? I couldn't remember. I couldn't remember if Mission Impossible Fallout was the one where he did break his foot. And lo and behold, the scene comes in where he's jumping a roof and you can actually see where his foot bends in like that. And I'm like, that's the point where he breaks his foot. My memory was refreshed just from seeing it. So, you know, I saw the movie itself. Do you believe that there are some other factors in play that could help refresh a witness's memory?
Yes, Tom Cruise could call you up and tell you which one it was.
But do you agree that they can be refreshed? Okay.
Tom
What
Cruise is gonna
about,
break his foot off.
let me see who I can pick. Ms. Davis, I'll go back to you. What about honesty and straightforwardness? Do you think that's a key factor in determining credibility? Okay. Like, let's say somebody gets up here, answers the questions just directly, doesn't try to dodge them. That would determine, you know, credibility. That would be a factor in determining credibility. Did you say yes?
Okay.
Okay. What if they're dodging or refusing to answer? Do you think that takes into account the factors of credibility? Okay. Everybody understand what I'm trying to say in that? Anybody disagree with it? Okay. What about, we'll go back to Ms. Gillespie. What about bias or interest? Do you think that has a tendency to play on the credibility and fairness? You do believe that it says though, or and you know, that's something that you'll look at right there. That's something that each of y'all will look at. You'll have the job of determining, did that witness have an interest in this case? Were they biased towards one party or another? Is there anybody here that thinks that, and you know, that kind of also applies to the jurors. Is there anybody here that, you know, they hear the testimony of one witness, they hear the testimony of the victim and think, well, I'm automatically biased against them. I have to believe what they say. Is there anybody that feels that way? Because everybody understands that You're to put bias to the side. You're to put sympathy. You're to put prejudice to the side. You're just supposed to decide on the evidence and the facts of the case and the law presented before you. Everybody understands that. Good, good, good.
You all get gold stars for jury service
So
today.
let me get into law enforcement testimony. Miss Vanahan, I'm going back to you right there because you said that your husband worked at Florida Department of Corrections. That's law enforcement right there. If your husband took the stand, you would think his credibility is kind of high, wouldn't you? But does that separate him from the other witnesses that will be called in this case? It doesn't separate him. So if you were to hear the testimony of law enforcement versus other lay witnesses or other witnesses that are not law enforcement in this case, you would treat them the same, on the same level. Okay. And that goes to each of you because I anticipate you're going to hear the testimony of a couple of law enforcement officers and a couple of lay witnesses in this case. Is there anybody here who, once they hear the testimony of law enforcement, that'll think, well, I'm going to think that their testimony has higher credibility than these other witnesses? Is there anybody that thinks that way?
Purple was about to raise his hand.
So everybody understands that every witness is supposed to be treated the same way. You're supposed to judge their credibility and all those other factors on the same baseline. All right, good, good. Now, is there anyone here themselves or a close family or family member or friend that has been accused of a crime? Ms. Davis, I know I kind of jumped the gun on that one a little bit right there. So let me ask you this question. Was it local charges? Was it in front of the state attorney's office? But that's a memory we don't want to refresh. Right. Is that correct? But do you feel like you were treated fairly? Sort of. You think that there may have been a few other factors where you felt that you weren't treated fairly?
She's rocking. She does not want to answer these questions.
That's all right. And I only ask that because, you know, like the judge said, I represent the state of Florida. I'm working for the state attorney's office. And are you going to let those factors of what you thought was unfairness or maybe a little bit unfair back in the day kind of influence your decision? So you're willing to put aside what happened then so that you can be fair and impartial in this case?
How we treat me personally.
Okay, I got you. Is there anybody else who has had an experience like that? Miss Milligan.
Yeah, my husband, it's been like 10 or 15 years. This actually, they charged him with homicide.
Mm-hmm.
Like he actually didn't hit the person. He hit the car that hit him. They still have.
Husband got charged with vehicular
I got
homicide.
You. And that was a state attorney's office case. And you said that was like 15 years ago or something. And I know that's a long time ago. Do you think that your husband was treated fairly? You don't think he was treated fairly at all? Any? Okay. Okay. Despite the fact, do you think he was treated fairly by law enforcement? No. The state? Okay. And it's important I ask you that because, you know, again, I represent state. We got law enforcement coming into play. Will you be able to base your decision fairly and impartially, even if you hear law enforcement testimony, given those factors that you say your husband wasn't treated properly or fairly back then?
I will say this. I will try my best not to have a bias, but I will take everybody's testimony with a grain of salt.
You'll take everybody's testimony with a grain of salt. So you're basically saying that you'll try to be fair and impartial, and you can be honest. Okay. All right. Is there anyone Anyone else been accused of a crime or had a friend or family member accused? Mr. Edenfield, your brother was?
They said he was a manufacturer. I don't know, but I know that there was one police officer that had a pass with him through high school, and we just felt that the evidence that was brought forth wasn't substantial.
Okay.
He was found guilty of charges. It's just, we just feel like there was a couple of police officers that had it out sometimes.
Was it a police officer case or a sheriff's office case?
It was a police officer.
Okay. This case will be, we may hear a couple witnesses from people from the sheriff's office and Mariana Police Department. Based on that right there, do you think that would impair your ability to be fair and impartial?
I don't think it would. I mean, like I always say, I take everybody's testimony. You know, it's fun.
Okay. So you're basically telling me that you'll try to be impartial. Okay. Is there anybody else?
But no guarantees.
Miss Stone.
My brother and my brother-in-law.
Okay. How long ago was that?
My brother-in-law was last week.
Last week? Oh, that's right. He was appeared. And that is our office right there. That'll be either Miss Jeffcoat's or Mr. Gill's case right there. And they'll be sitting second chair. It'll be me doing, first chair duty while he or she sits there. Based on that right there, does that sort of impair your ability to be fair and impartial?
Is it a problem that you're
You don't
prosecuting
believe
my
so,
brother
despite the
next
fact that, your brother is currently being prosecuted by our office. You can still be fair and impartial.
She's
okay.
gone.
Miss Rowley.
He was treated by law enforcement, or that's what I was told. And I seen pictures that it won't mess with my ability.
Be fair and impartial. Okay, so yeah, that won't affect, your opinions on law enforcement or the state. Okay, all right, great. You beat me to the punch on that question right there. All right, anybody else? All right. What about same people themselves, a close family member or a close friend? Do you know any of those that have been a victim of a crime before? Nobody. Okay. That kind of. Okay. So you were the victim of a crime, but it was never reported. What crime was that? It was sexual assault. I'm sorry to hear that. Okay, hold on.
He's like making a note. Do you know there's no statute of limitations there? And we'll be talking to you later. We might be able to prosecute.
Beat me to the punch again right there. Even though you went through that terrible experience, it won't impair your ability to be fair and impartial. Okay, because this is, like I said, a victim crime. And that's not automatically going to make you say, well, I'm biased for the victim. Okay, you're fair and impartial, and we'll hear all evidence and base your decision solely on that evidence and the law. All right, perfect. All right, so I'm going to go through a couple of the witnesses and parties that will be involved in this case. And if you recognize their name, please raise your hand and let me know if you know them. I'll go over their names again. So either joining me will be Chief ASA Shayla Jeffcoat. Does anybody recognize that name? Okay, so nobody knows Miss Jeffcoat. What about ASA Lawrence Gill? Nobody? Okay, good. All right, so Hannah Laree Batista. Does that name sound familiar to anybody? All right, what about Chelsea Elena Jackson? Okay. Officer Brandon Moore. He's with Mariana PD. Let's see if we can go for the perfect one. and Deputy Truett Corbin with the Jackson County Sheriff's Office. Look at that. Look at all y'all. All right. So I'm going to wrap up right here, and then it'll be Mr. McDaniel's turn to ask you a couple of the questions very similar to mine. But let me just leave you with this. This case is set for trial on Thursday. It's going to go probably 9 o'clock to the afternoon, early, maybe mid-afternoon. Is there anybody that won't be available on Thursday? Mr. Edenfield, you work out of town? Okay, and you're working on that day? It's going to be going. Okay, all right. Miss Milligan, you look like you were about to raise your hand.
As long as it's done and over Thursday, I should have done that. I'm going out of country.
Okay, yeah, we should be done by the end of Thursday, so you would be available for Thursday. All right. Anybody else? Miss Bess, you look like you're raising your hand. Yeah, we should be done before then. But knowing that, you would still say you're available on that day. Okay, anybody else? All right. So.
Hey, Josh, just dump the body out of it and it's yours.
Like I said, this will be going on Thursday. Oh, wait. Hold on. Miss Bess, I do have a question to ask you right quick. I can't believe I forgot to ask you this, but you said that you know Judge Mercer, correct? Now, you understand that Judge Mercer, he's not involved in this case other than just being like a non-biased referee, basically. He's just here to make sure that the case goes smoothly.
Hang on.
He's to make sure that he reads y'all the instructions. He's to make sure that, there's no, in layman's terms, tomfoolery about.
Does that mean most referees are biased?
It'll basically be me and Mr. McDaniel involved in this case right here. And I have the burden of proving this case beyond a reasonable doubt. But knowing that Judge Mercer will be overseeing and playing the referee, do you think that'll affect your ability to be fair and impartial in this case? Okay. And you understand what his role is and what our role is. Okay. All right. So on that note, on the note of judging, I got to tell every single one of y'all, I know there's a lot of people that usually will have their fundamental beliefs that say, I don't know if I can judge this person because only God can judge. Here's an important note to kind of help relieve you of that stress. You're not judging the person. You're just judging his actions. And you're judging his actions based on the facts that will be presented to you. You are deciding the facts. Now, is there anyone here who actually, let me rephrase that. Is there anyone here who, if the state proves this case beyond a reasonable doubt, says to himself, well, I don't feel comfortable giving him, a guilty verdict, so I'm going to vote not guilty? Is there anyone who can't act that way? So everybody understands that, if you have a substantial conviction of guilt, you must vote guilty. All right. So is there anyone here who, for whatever reason, cannot give their undivided attention on Thursday to this case? All right. Y'all are one of the best panels that I think I've had in a long time. So I appreciate y'all's attentiveness. I appreciate your patience and your time. And thank you for hearing me ramble up here. Thank you, ladies and gentlemen.
Okay, now defense gets a turn. Hopefully he's better.
Mr. Mitchell.
Needs to connect.
Good morning, now. I'm John McDaniel, attorney for Michael. And I was going to ask y'all a few questions also. What do y'all normally think about when you see somebody with tattoos on the face? Anybody?
Regret.
Jake got y'all all quiet. Nobody wants to talk. He done all the talking for y'all, I guess. Go ahead, man. I appreciate that, absolutely. And why is that?
Because you don't know the backstory. They could be, the most honest with the hardworking person there is like they got tattoos, they were on the face and everything. They're much kind of hard to keep out.
Correct. Yeah, and it's a lot of reasons why people do certain things. What's some of the reasons they may put tattoos in the face?
Remembrance, could be trauma to something like.
Well, Michael's a tattoo artist also. So does that also, if someone's a tattoo artist, maybe that kind of puts it in scheme of things why someone might have tattoos all over them? Yeah. Does anyone have any biases against someone when they see someone with tattoos? It's like, yeah, I just can't do that. Someone's got tattoos. Nobody? No. Derek, you got any problems with people with tattoos? You got tattoos? Okay. Who else here has tattoos on them? So quite a few then. So, sometimes I get jurors in here, not a one of them's ever seen a tattoo, I think. So we got that kind of covered. So you don't think there's going to be issues with someone? Y'all can listen to the facts and not worry about if there's tattoos on someone or anything like that? Okay. Who all here is currently married? Just raise your hand. And who here has been married for over 20 years? Over 20 years. Yeah. So, Wendy, how do you discipline your husband? Without getting yourself in trouble. I'm not saying get yourself charged with a crime because they went through a lot of stuff here to try to say that you might be a criminal. But what happens between you and your husband sometimes? Been married for over 20 years. 20 years, I know y'all been through a lot though, huh?
Yeah.
How many kids y'all got together? 2? Yeah. And y'all had disputes before, I guess, haven't you? Yeah. And how do you correct him sometimes? Put him in his place? I don't mean to put you on the point. I'm just, you got to put him in his place sometimes. And, and Mr. Mitchell went into this thing about, if you touch someone and this and that, how many times y'all touched each other that he described that you're a criminal? A few times?
If you're in the van.
So you're the person that he's describing as a criminal. Is that right, Wendy? When he describes him, he's describing you. Is that what we're saying? It's all in the past. Nothing vicious. Nothing vicious. And what is vicious? What is that?
He never hurt something like, never mind, I had a black eye.
I'm not worried about you having a black eye. Maybe you misunderstanding my question. I'm worried about your husband having a black eye. How many times you gave him a black eye? You never gave him a black eye? Well, he got a better wife than I do. You know what I mean? So, anyone else here that's been married over 20 years? I remember I see some hands come up. Yes, ma'am. How's things been going?
He's got a better wife than I do.
43 years.
43 years.
You might not have a wife when you go home.
Man, now 40 years ago, when y'all were just young bites, because I couldn't think you'd be old enough to have a husband for 43 years. So when you were a teenager, when y'all were fighting, y'all get into some things sometimes.
We've never fought physically.
Never fought physically. Never had. You never had to straighten up your husband.
No, we don't have that kind of relationship. We communicate. We do ours through communication.
Yeah. Well, good. He might be the only man in the world that does that. Through communications. Mine says I don't communicate enough. So, hey guys. All right. So.
I'm guessing your wife isn't watching either, Mr. Attorney.
Who here has been a victim or been involved with, disputes with family members and spouses and other things? Anyone here had? I know you have. So who's had some disagreements and fights with your family members? Go ahead. Just I always know a Cottondale guy's gonna tell me the truth, because everyone else may keep their hand down, but go ahead. What you got? Well, Sean, you and your brother, y'all about killed each other. Yeah. What was your brother's name? It's Christopher. Yeah. So what kind of fights y'all get into as a kid?
We, wrestle as kids, arguments.
Now, I remember Sean. So Sean, I'm not your brother Chris. So Chris, when he got older now, y'all, even if y'all were over the age, y'all still fought sometimes, didn't y'all? Yeah, that's just part of being a brother sometimes, though. Yeah. Well, where's he at now? Okay. Anyone else been involved with anything like that? Any kind of, mild violence, disagreements? How about disagreements? Shouting matches. Come on now. Go ahead and tell me something.
Violence? Tell me something. Give me something to work with.
Yeah. And which family members have that been with?
My father.
Your father? And that was after you had, I guess, got married and went on your own, or was that before when y'all were?
After.
What kind of disagreements did y'all get into?
Well, he was or not alcoholic. He thought it was okay to keep shoving alcohol down my husband. And we just said we don't need to be part of it. And that we were going to split ourselves. And he started to party with us and said, I'm going to walk away from this. I don't need that in my life. He finally hurt me. I can exclude myself from violence and walk away.
Yeah. And you and your husband still together?
Absolutely.
And you straightened him up, I guess?
No, he straightened himself up.
You had to do an encouragement to him, or?
He is an adult who can make his choices, but I let him know that if your choices affect others, you're responsible for that too.
Mm-hmm. What about you, Precious? You seen some of that? I seen you nodding your head there.
I mean, I have not seen it, but I mean, I just agree with, what she's saying, everybody, we're adults, you're responsible for your own choices and your consequences.
Yeah.
I agree.
Absolutely. Anyone else have any thoughts on that? What about you, Derek? You see anything like that, or y'all been involved with it before? I know you said you were divorced, I guess.
Yeah, we just got arguing, yelling matches and stuff like that.
Absolutely. Yeah, I mean, that's pretty normal. That's not, anyone else been having yelling matches with their spouses or significant others? Sometimes it seems like the world's coming to an end, I guess. What you got, Delilah?
Well, my husband died last year. The anniversary is coming up, but we have arguments because we were together 24 years married. We got married in 2015. Of course, we got to shouting matches and stuff, but usually I'd go in the other room and pout.
Did it work?
And give him the silent treatment for a few days.
Did that work, I guess? Well, good.
Never thought I'd say this, but I want the other attorney back, the prosecutor. This guy's a bit of a...
Jake, Mr. Mitchell went into this thing about refreshing memories, and I like to call it rewriting memories. How many think that your memories are permanent? They can't be changed. What you saw is what you saw. Anybody? Who really thinks memories are fluid and they change sometimes? Sometimes outside influences change those memories. Someone's got to have some kind of thought process on this. Yeah. Yeah.
I have said
You think when someone tells you what that memory is, that might help refresh it? Or it might actually change the memory?
I don't know if it's changed, but it could refresh it.
Yeah. How many's ever watched some of those documentaries, those innocent projects and some of these other things? Anyone ever seen them? Yeah, you've seen some of them, haven't you? Anyone else seen them? Andrew, tell me about some of those ones that you saw where it involves memories. Tell me about maybe those documentaries you saw. Did you see people that they got refreshed enough on their memories that they admitted the things they didn't do?
I think so.
There've been people that you tell them what your memory is enough that they'll say what you're saying. In a movie?
Yeah.
You don't think anyone's seen this in real life where if you tell someone enough, that they'll kind of take up that memory as that's what it is? What are some of those innocent projects where they admitted to doing something heinous and they come back where years later found out that they couldn't have done it even though they admitted to it? They were not there. That was not their DNA that was there. Anything else? Have you seen some of those before? So how did their memories get placed in there to say that they did something that we look afterwards and say clearly they did not do? How does that happen? Somebody fed them a memory enough to say, this is what happened, don't you remember this? And it becomes part of a memory. I mean, you've seen that happen on some of those documentaries, and, anyone else saw something like that? Heard something like that? It's Gabrielle, Gabby, you shaking your head? You don't think that's possible, or? Oh, I'm sorry. What do you think about it, Gabby? What's your thought process about memories? Yeah. Can they be shaped? Absolutely. Yeah. If someone's in a stressful situation and law enforcement's telling them certain things, then is that a stressful situation? Yeah. And I know Jake was asking a lot of questions about, fairly impartial and trusting the government. And it's a Jackson County. All y'all from Jackson County. How many of y'all trust the government? Anybody trust the government? I mean, I know I'm in Jackson County. I usually get one or two that trust it. Does anybody trust the government? Who does not trust the government? So we're getting about most of the hands up now. So there is a little bit of distrust in the government. And Ms. Stone, where does that distrust come from? And sometimes they speak rigidly, I guess, and they say, well, if you touch someone, it might be a battery, and things like that. Well, touching someone, really? I mean, is that a battery? We went to this unlawful, unwanting touching or something. Could that be, you want to lose your common sense and go into a government bureaucrat to say, yeah, that's a battery? Who here can keep their common sense on what a battery is? Everybody? Who here can ignore some of the government stuff when they say, well, if you touch someone, that's a battery. If you walk past them and you intentionally touch them, that's come on now. In Jackson County, I mean, sometimes we have a little bit of distrust for government officials. So, all right. So, try to figure out who's the person that's got the best attorney joke, you know what I mean? Because I know there's some of y'all out here. Has anyone got a really good attorney joke?
Bingo.
And I kind of got my feeling it's going to be a school teacher from, Gordon probably got one. Gordon, you got to have a good attorney joke now, don't you?
Why does it take so long to bury an attorney?
Hey,
because the gravedigger doesn't want to stop digging.
How long you been over there?
Put them deep.
First year there?
Put them deep.
Okay. Anyone have any good attorney jokes? Nothing? Well, I did have some, but I think I about forgot them all because I get laughed at every time I say them, so I ain't going to say them. I was hoping someone else would give me a good one to laugh at. He went down these standards of proof and stuff, and beyond a reasonable doubt. What is beyond a reasonable doubt for? I mean, to make the state prove that. I mean, why is it there? Ms. Couch? Why don't we make them prove, why don't we make the state prove beyond a reasonable doubt?
I mean, if there's doubt, then it's like, how can you say somebody committed without doubt?
Yeah, we want you, when someone's guilty of something and they can be, not saying they will, but they can be put in jail, freedom taken away, it's beyond a reasonable doubt. Does anyone know some of the other standards in legal that we use? What about preponderance of the evidence? So I'm going to try to give you a visualization. Does anyone know what preponderance of the evidence means? So this right here, if you're in a civil case, and most civil cases, not all, but most civil cases are preponderance of the evidence. So I don't want to say numbers, but, slightly more likely, and they can be found guilty. What you think about it, Ms. Patterson? Is that a fair standard? Is that a fair standard to have someone that can be guilty slightly more likely? Yeah, so that's one standard. That's in the civil division, most civil cases. Some others are clear and convincing evidence. So we go from this right here to clear and convincing evidence is going to be way up here. Clear and convincing evidence, there's a lot of cases that involve that. Some of them involve with taking kids from their families. You got to have clear and convincing evidence. That's somewhere around in here. So if you're going to take someone's child away from them most of the time, it's somewhere around this clear and convincing. Within criminal standards, we have the highest standard there is, and that's beyond a reasonable doubt. Does anyone have any problems with that standard? Beyond a reasonable doubt. I mean, it's what it is. You hear the case, the judge will give you exact definitions of it, but most of us know what beyond a reasonable doubt is, And Donna, what's your definition of beyond a reasonable doubt?
Say in my heart that I was convinced the person.
Correct. That's a good explanation. Yeah. And Stephanie, why do we make the state prove beyond a reasonable doubt?
Because even though was arrested, so
yeah, and who does that? Who makes the determination whether he's guilty or not guilty? The jurors, you. So whoever sits in this jury will make those determinations. And I think more and more, who we want to protect is you, because you got to go home and sleep at night, correct? So if you're going to say someone's guilty of something and possibly take away their civil rights, you want to make sure in your heart, like she said back here, that he's beyond a reasonable doubt. He did it. There's no doubt in my mind. That's the standard that has to be shown. You're okay with that, though? Does anyone have any issues with basically saying that I want the state to prove beyond a reasonable doubt that he did whatever he's accused of? So. There's going to be a lot of witnesses. Well, not a lot. There's just a few witnesses that are going to be coming. And Wendy, what do you want to hear from Mr. McCarr? Do you want to hear from Michael? Do you want to hear from him when it comes his time? And I do too, and I've already heard it. So if he doesn't testify, under our law, a defendant does not have to testify because the state has to prove that he's guilty beyond a reasonable doubt. Now, if he chooses not to testify, is that going to, the burden still on the state? They got to prove beyond a reasonable doubt. Does anyone think that they have just absolutely got to hear from Michael on this case, or else they're going to, take that against him?
I just knocked my laptop
Go
off
ahead,
the stand and caught it midair.
Have to, but I'm able to, at least for me.
It'd be helpful, huh? Yeah, I think that's reasonable.
required, but it would be helpful.
Yeah, absolutely. Yeah, I think it'd be, yeah, I agree with you. I think I'd be the same way. It'd be helpful, but if he doesn't testify, you can listen to the evidence and determine on your own, because sometimes I think people don't realize just how scary it can be up here, maybe. I mean, who's gotten pulled over by a police officer and their blood pressure goes up? Yeah, I mean, mine still does. Hey, when I see an officer behind me, my blood pressure starts going like, what the heck did I do? There ain't no lights on or anything. I still get kind of scared, Is it reasonable that if you're going to go against a experienced prosecutor and they're going to ask you all kind of questions and to be a little bit scared? That might be a reason why, if he chooses not to testify, that if he didn't testify, that, heck, I don't want to put myself through a cross-examination that's going to beat me up by the state, the government beat him up, That's okay with all y'all? Y'all don't have any issues with that? Okay. So this is the only time that we can talk. Does y'all have any questions for me, I guess, that I might can answer? I mean, or anything that we've talked about that you want to say? Somebody's got to have some kind of question. Anything? Well, Mr. Mitchell's going to come back up here and do a follow-up on questions I asked. And, after that, we're probably going to end up letting y'all go home as soon as we pick y'all real quick. It won't take long. And I look forward to seeing you all Thursday. And we'll hear this trial. And I don't anticipate it'll take very long. I suspect, like Jake, early afternoon, this case will be over with. Any questions from anybody? All right. Thank y'all very much. I appreciate it.
Mr. McDaniel, Mr. Mitchell, I have a question.
I'm eating this trail mix. It is delicious. Mrs. R.A. got it for me. It's called the Wild Roots Omega Trail Mix Powerhouse. Almonds, protein chocolate flavored chips, pumpkin seeds, walnuts, granola clusters, strawberry flavored cranberries. I didn't know that. Banana chips, banana flavored clusters, and strawberries. This is just good. Yes, affiliate link. Everything is, but we get ours from Sam's Club. I think it's a little cheaper than buying online. The enchiladas are gone, by the way. They're all gone. Now the jury's all relaxed. Now that the attorneys who did a terrible job and then a worse job consecutively, now that they've gone up to talk to the judge, everyone's hoping that it's not them. I like the pumpkin seeds. They're green pumpkin seeds. I guess they all are. But just little tiny. That was good stuff.
All right, ladies and gentlemen, Mr. Mitchell has a couple more questions. Shouldn't take just a minute.
Skilly, I just have one question to you. I kind of noticed when Mr. McDaniel was asking you about proven beyond a reasonable doubt, you made some comment about how you think you have to prove he's not guilty beyond a reasonable doubt. You understand, and everybody else understands, that you don't have to prove that he's not guilty beyond a reasonable doubt. You just prove that he's guilty. There is no burden for not guilty. Everybody understands that, right? Okay. And there were a few more witnesses that I just wanted to get out, see if anybody recognized them. Kimberly Ward. Does that name sound familiar? What about Heather Oliver? What about Sophia Oliver? All right. That's all I have. Thank you, ladies and gentlemen.
Thank you. So, ladies and gentlemen, what we're going to do is we're going to meet over here at sidebar and let the attorneys pick the jury. So feel free to talk among yourselves. Just keep it at a manageable level. It shouldn't take more than a few minutes.
We can hear defense.
If somebody wants a restroom break. I can't, give me 5 minutes. If we don't pick this jury in 5 minutes, we'll do that. But once I let you out of here, it's going to make everybody stay another 10 minutes or 15 minutes. So give me 5 minutes. Mr. McDaniel, Mr. Mitchell, whenever you're ready. Thank you.
No breaks. We don't give breaks here. We don't have time. You're going to have to hold it. They are comfy chairs. They recline. They spin. They look leather. Big stretch. There we go. All right. They have glider chairs. And I mean, all we need now is like an ottoman. Are they actual gliders? That would be funny if they rocked back and forth. Who could be on this jury? I don't know. I don't think I could sit on this jury. I'll tell you this. Both sides did a terrible job putting the jury at ease and to make them feel comfortable enough that they could answer the questions. And part of the problem is they sure started with bad questions. And I blame the prosecutor first for like moving up there first. And he's like, hey, let's kick things off with, hey, we pulled your criminal record. It looks like you were charged with something. Why didn't you tell us about that? Yeah, there's a quick way to be like, oh, crap. Oh, crap. Why not start with the attorney joke instead of end with it? And, yeah. All right. I don't want to be on this jury. Nobody does. Trial's not till Thursday, but they have, we can only see part of the jury. So we can see the knees of some behind the TV, and then there's like another row. We see the front row and then the 2 rows behind. So the front row is seated in the well, actually. They brought those chairs, and the lady who's bouncing her legs right above, like straight above me. That's the front row. And then we have 2 more rows behind them that we can see in the bottom right-hand corner. That's where the orientation is, and that's how it works. But this particular courtroom always tries or seats a jury in this manner. You get to see everything, hear everything, unless they go up to the judge to take it as a sidebar and talk to it personally. But if you are ever called to serve on a jury, you can always tell the judge, every time they ask you a question, if it's personal, I'd like to talk to the judge privately. You do have to answer the question. You're not able to say, I don't want to answer that. It makes me uncomfortable. Unfortunately, you don't have that right unless the judge deems the question is just not relevant. So don't be afraid to raise your hand and say, I'd like to talk to the judge up close. Let's go up there on the sidebar and discuss this. Trust me, it would be a lot less embarrassing to do that than to sit there amongst a pool of jurors and have to talk about something that you don't want to. All right. For those that joined us last week for the Enchilada live stream, this is we did this on Thursday night because Thomas was traveling, unable to join us for the podcast, so we tried to do a little filler. It was not nearly as entertaining as the podcast, and it took about 2 hours, and dinner was served about 9 p.m., but it was delicious. It was the best tasting food I've ever had on a podcast night. It was really, really good. So might want to go back and watch that if you haven't. Are the enchiladas gone? They are gone. Between me, my wife, and my family, we ate all 3 pans of enchiladas. I finished off the last 2. Not 2 pans, but the last 2 enchiladas yesterday. So I don't believe in keeping leftovers more than like 2 or 3 days. At that point, they start growing. So then you can't keep up with eating it. Rethinking my kitchen design for podcasting. A couple of you made comments about our kitchen, how it's clutter-free. This is, the kitchen is Mrs. R.A.'s domain. This is my domain. You can guess who controls the kitchen. Yes, and if you look closely, we do have a can of Raid right up there. I had to use that over the weekend as well. So, So yes, she keeps when she got her new kitchen, which is part of the deal. When we got this house, the kitchen was terrible. When it got destroyed, she said, "If I get a new kitchen, I want it the way I want it." And so she did design it. She designed the placement of the cabinets, the counters, the bar, everything. It's all according to her design. And she wanted room for everything to be put away, so nothing lived on the counter. And that's the way it stayed. Mostly. Yes. Yes. The only thing that's not accurate about this is this makes it look organized and clean, and it is not. Don't look below desk level. Did you build it? I did not build it, but we had a family friend who's a contractor build it. It was part of an insurance claim because my son destroyed our kitchen, literally. Got it. Is a recipe posted somewhere? You have to watch the whole video and just follow along, because we sort of, I winged it a little bit. I mean, I added a little mule sauce and seasoning and stuff sort of to taste. But Marcy, is it your birthday today? Happy birthday, Marcy. Where's Marcy? I'm looking for Marcy. There it is. Today I turned 75 years old. Thank you for the laughter and knowledge. Happy birthday to you. Happy birthday to you. Happy birthday. 75, dear Marcy. Happy birthday to you. There we go. Happy birthday, Marcy.
All right, ladies and gentlemen, we've chosen a jury in this case. If I call your name, you'll be on the jury in this case, and you just stay seated. Everyone stay seated till we get through. So the jury on this case will be number 136, Ms. Bush, number 141, Ms. Gillespie, 149, Mr. Addison, 150, Mr. Kaufman, 160, Ms. Bryant, 161, Ms. Patterson, and 164, Ms. Couch. That'll be the jury. For those of you I did not call your name, you're free to go. I've been advised that Judge Garcia has plenty of jurors in the other courtroom. She will not need you to come back down there. Thank you for your time and service. One more thing I need to make you aware of, and that is if you receive a jury summons within the next calendar year, and you have the right under Florida law to contact the clerk's office and say, I've been summoned in the last year. I showed up. I was not chosen, but I do not want to show up again. That's for 1 year from today. You can show up and be a juror if you wish, but you don't have to, because Florida law sets it at once per year as requested by the juror. Thank you for your time and service. The 7 of you I have names called, please stay where you're seated while the rest of the jurors leave. Thank you.
Purple shirt got picked. You can't.
I can't hear you, ma'am. I don't know what this is. I don't know what you're talking about, ma'am.
I'm sorry.
Dawn.
The whole front.
Do you know what form she's talking about?
Oh, there's one person on the front row that got picked. Everyone else.
Is that something they sign down in the other courtroom before they come down here? We've never done that before.
Just sign the
paper. All right, so the 7 of you remaining, we'll make sure we've got our right 7. We've got Ms. Bush, Ms. Gillespie, we've got Mr. Addison, Mr. Kaufman, Ms. Bryant, Ms. Patterson, Ms. Couch. So we have a jury trial starting Thursday. I need you here at 8:45. I have first appearances at 8:30. We'll get through the first appearance as quick as we can. We're going to try to start at 9. Last month, we had a juror late. So this month, I've asked the clerk, let's give a handwritten notice. It's got the time on it, because sometimes with everything going on, people get confused. But if one of you is late, that delays the whole trial. Everything's going to be late into the day, which means you're going to get out of here later. So I need you here at 8:45. There's benches outside. Please do not come to the courtroom. We have some pretrial matters going on in here. Wait on the benches outside. When all 7 of you are here, then one of the bailiffs will let me know that you're here, and we'll let you into the jury room, let you have a seat. We'll take care of anything else we've got in the jury room. Mr. Rooks, our clerk of court, always provides coffee. There's some coffee. There'll probably be some snacks in there. Maybe some bottled water, maybe a soft drink or something. Nothing fancy, but some basic stuff. But I need you here at, I said 8:45. 8:45, and that's what your written notice says.
The last juror is the jeans in the top box straight up above here. Not the lady right by my
In
finger.
the event of an emergency, such as a hurricane that happened a couple years ago, or something crazy like COVID, we need to be able to notify you. So I'm going to ask that you get a phone number from you for the clerk. So the clerk will have a number if something like that happens, so we can notify you. But as of right now, unless something changes, which is very, very rare, we need you here at 8:45 in the hallway. Do any of the jurors have any questions? Yes, ma'am.
Downstairs, just come straight up.
Yes, ma'am. There's some benches out there in the hallway. Just have a seat on one of those benches. Any other questions? So if you would make sure the clerk has a phone number for you, the attorneys, anything else with the jury before we let them go? No. We'll see you Thursday. And if Ms. Williams, to get your phone number, please. The last thing is, as you're leaving, I need you to show up Thursday not knowing any more nor any less about this case than you do right now. Don't think it'll be on newspaper. You never can tell about social media, but if there's something there about the case that you've heard a little bit about today, don't read it. Don't listen to anybody. Don't talk to anybody. I need you to show up knowing what you know and nothing more or less. Okay? Thank you very much. We'll see you Thursday at 8:45.
There are 7 people who are not thrilled. Not thrilled. Not happy in the slightest. Everyone take your parking validation. There you go.
Ladies and gentlemen, if you're watching by Zoom or YouTube.
If you're watching, stop, because we're done. We're done. All right. What did Spartacus say when the lion ate his wife? Nothing. He is gladiator. What? I haven't watched that show. Oh, he is glad he ate her. Glad he ate her. Thank you. I needed Genjo to spell it out for me, and it makes a lot more sense. I'm like, that sounds like a terrible movie. The guy just stands there and does nothing. Glad he ate her. All right. I'm loving this. This is going to be my lunch. This got a little cup full of they say strawberry flavored cranberries. They taste like strawberries. We are going to be watching a little bit of Lori Vallow. But in doing that, we're going to... Wait, hang on. That's not it. Let's go here.
On the police made knowingly, voluntarily, if understanding of the consequence. I will accept defendant's pleas, enter findings of guilty based on those pleas.
Lori Vallow is going to start in an hour.
Ms. Myers that I added
minutes.
restitution reserved to the plea form.
Okay, thank you. And were you aware of that, Mr. Mottman?
Can you repeat that?
Yeah, and so was there an accident, Ms. Kidman?
One of the vehicles that was forced off the road collided with one of the barriers.
Okay.
So I'm not sure if restitution would come from that. I informed Ms. Myers that that would be part of the offer. It was not listed on the plea form. I told her that I add restitution reserve to the plea form. She didn't respond specifically to that, but I did let her know.
Okay. So on the reckless endangerment charge for the vehicles that had to move out of your way, apparently one of them was damaged. And as part of the offer on that plea to suspend all the jail time, Ms. Kittmacher indicated to Ms. Myers that she would be seeking an additional condition of reserving restitution, which would mean that you potentially would be financially responsible for the damage caused to the other.
I've already dealt with my insurance company about all this.
Okay, but that would be a condition, the payment of that. And, you know, if it's been paid, fine.
Yeah, they're not pressing charges.
Okay. But just understand that would be a condition of the sentence. Okay. So you understand that?
As much as I can, yeah.
Okay, we're about to do one more jump. One more jump. Ready? This is a Josh special. Here we go. I'm not sure how soon this is going to kick off, but apparently this guy in blue may be pro se. This is from today. After this, we're going to go to lunch. So we have over an hour before Vallow starts. Let's fast forward just a teensy bit, shall we? God bless you, sir. Oh, nice. You didn't all want to see that, but that's good. Is that a Detroit Lions shirt? Here we go. Oh, sorry. Missed it. She was about to start.
Ms. Niederhoff?
Yes, Judge.
Are you covering James Crowley today?
I am, Judge.
All right, have you had any contact with the police department? I have, and Mr., just for the record, Mr. Crowley is present in the courtroom via Zoom. We had this misdemeanor case. It looks like it is being escalated to a felony or elevated to a felony. But Officer Cologne's not checked in. Okay. Have you had any contact, or do you know if the prosecutor you're filling in for is in any contact with, I mean, I need to do a swearing before I can do an arraignment.
Yes, Judge. I have not had any contact with him, but I can get in contact with him quickly.
Officer Cologne?
Yes.
Okay.
And Judge, I think the way the prosecutor I'm filling in for APA, Nor Alloway, she was asking for the misdemeanor case that is up for today to be dismissed, and then he is being arraigned on this new felony.
Yeah, I understand all of that, but I'm not dismissing the misdemeanor and arraigning him on a felony before I've sworn the felony in.
Yes, Judge.
So I need the officer here so that I can do things procedurally correct. Yes. And Mr. Crowley, you just have to sit tight with us for a few minutes.
Okay, Your Honor. Yes, Your Honor.
All right, so everyone sit tight. We're waiting for Officer, is it Collip or Cologne? I'm sorry.
Collip. I will get in touch with you.
All right, well, we'll just wait. Mr. Crowley, if you could just mute yourself. It's going to be a few minutes. We're waiting for an officer.
Okay, yes, Your Honor.
All right. And while we're all, oh, she's gone. All right, never mind. We'll do it next time.
I'm back. I'm back, Judge.
I was just going to ask Ms. Niederhoff, did you have a chance to speak with Mr. Crowley regarding this case at all?
I did, Your Honor. We spoke a little bit ago, maybe 10 minutes ago.
Okay, about your proposed protective order?
I did, Your Honor, and I sent it to him via email, and I had him read it over, and I am not sure if he agrees that what his position on it is.
All right, Mr. Crowley, we'll give you some time. If you want discovery on this case, the prosecutor is requesting a protective order.
Your Honor.
Yeah.
I did look over that protective order, but I can't help but believe that I'm under the impression that if I do that, I'm signing away my right to face my accuser. Anyone who comes forth, because any person, any human being that comes forth with information in the form of an allegation is an accusation against me, and I have the right to face my accusers, Your Honor.
You have a right to face your accusers in court. in a courtroom. The protective order is, I've not reviewed the protective order, but I presume it's standard language. It says you can't disseminate those documents.
Well,
You can't give them to other people. You can't, they're for you.
Your Honor, in no way, shape, or form. Well, can I just speak freely for a moment, Your Honor? I'll make it short for the court.
Mr. Crowley, wait a second, because Ms. Niederhoden, I'm sorry, before we have this conversation, I want to see the language of the protective order, so I'm not arguing against myself here. I want to see what it entails. And so I'll give her a few minutes to bring that to me. She's got to call an officer, and we'll just put it all on at the same time.
Thank you, Your Honor.
But I want to see the order. Thank you.
The judge knows where this is going. She has been down this road before. She heard the key word uttered by Mr. Crowley when he said human being and rights in the same sentence, and then spat out the window, which we all just watched. She knew, and then smeared it on his sleeve because he didn't spit very well. She knew. She knew that he was going to step where no man should step, which is the no man's land of pro se. And we're just getting started. We're just waiting. We're going to chill here because we do need an officer.
I'm going to have to get an attorney.
Mr. Crowley, you need to mute. Wipe the forehead, polish it up with the sleeve that we just wiped our spittle on. That makes it nice and shiny. There's another one. Right out the window. Good aim. Good aim. Got a lot of ink on the fingers and the hands. Uh-oh, another spit coming. I can see it. He's prepping one. He's spitting mad. I didn't pause to see what his knuckles said, but oh, there it is. Oh, patooey, a double spit. 2 spits. Do you want to wipe anything on your sleeve now? Are you good? Nope, he's not done. There's more. Yeah. Got some on the mustache. It's hard to spit when the mustache gets in the way. That's why you keep it trimmed. And there's another one. A little snort there to follow it up. Usually snort first, then spit, but he's doing it backwards. So different style. I guess everyone has a different style when they spit, but there's another one. Wipe that up. Yep, right there. You got it. This is a bit gross. To go straight from here to lunch, Josh, what were you thinking? His objection is he doesn't want to sign something agreeing to not contact his accusers. He says, I have the right to face my accusers. He does, in court. I'm sure the protective order is going to say this. But they don't want him to talk to the accusers outside of court. The accusers don't want to talk to him or be spit at. Okay, documents incoming. Those are other caseloads, not this one. Just waiting here for an officer. Another spit coming up, maybe. Just notice the throat work. See the wings. That's got to be a painful tat. For those who've got one, I've never gone under the needle for that. I mean, the closest thing I've got is I got my booster for tetanus one time, but and that hurt like crazy. But does a neck tattoo, is that one of the more painful ones? Judge bailed. Let's see if he becomes a little vocal here. Jenny G, finally hit my 1 month milestone. Thanks for all the great content. All right, Jenny G, congratulations. Your courthouse has just changed colors. First of many changes. Thank you. Okay. Yes, neck hurts. Hands hurt. Feet hurt. He's got... I don't have neck, says Ryan, but... Call a throat tattoo a threat? Are you just making up words, Greeners? Hey. I don't want to skip ahead to when the judge comes back because his mic is still hot and he might talk, but lunch is calling. So let's do a couple skips. No. Judge comes back right here. Here we go. Kathy B, upgraded membership to the jury. Kathy, thank you very much. Welcome to your new seat. It is a padded seat. No more hard benches for you. Welcome. Thank you for your support of the channel. Greeners, I saw where you're going there. Collarbone would be painful. Collarbone, that must hurt because there's not much skin there. Your collarbone's like, you got like, that's, no. Nope. Jonathan comes in and says, Greeners would never make up words. True. True dat. True dat. We're going to fast forward a bit, at least till the defendant shows up. If I use the right remote, it will work faster. Skip, skip, skip. Skippity, skip, skip. Skip, 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 skip. We're saving so much time. Oh, he's back. He's back. Okay. Jennifer Juniper, member for 15 months. Taking forever to get my pink courthouse. It'll be worth the wait. Thanks for all you do, RA. Love y'all. Thank you, Jennifer. Thank you. Congratulations. Judge is going to hit that little remote. When you look at the remote, it's actually going to shine a light. That light is invisible to the human eye, but is captured by the camera. It's called infrared. This science tip.
Hello?
Beep, beep.
All right, give us 1 second. We're trying to get everyone in the courtroom.
Yes, of course.
Cameras often can see that infrared light. People
Did you
can't.
send Harrison to probation?
I got
He going down to probation, Harrison?
Can we hear the story about how your son destroyed the kitchen? Oh, he did. CW, we've shared it a couple times. We might do it again. Let's see. Jennifer Ashby for James Crowley. Did she change? Was she wearing that before?
All right. We're on record. This is 250334SM, the People versus James Crowley Council. Can I get your appearance?
Good morning, Your Honor. Sarah Neighborhood for the People, P88069.
She's in
All right, and Mr. Crowley, can you tell me your first and last name?
Good morning, Your Honor. My name is James Crowley.
All right, so we have a first issue, or a couple issues here. The first is that the people are moving. Mr. Crowley, you've decided to represent yourself. Is that correct?
Yes, Your Honor.
Okay, and at this point, we're still talking about a misdemeanor charge. So this was the settlement conference day for today. I see the complaining witness is also present. Ms. Ashby's present today. We have a jury trial set for July 25th at 9 a.m. That would be in person. I was presented this morning with a felony complaint, but the officer was unaware, is not available to swear it in this morning. So I'm continuing this hearing for a week. And in the interim, so that's my decision on that. We're gonna come back next week. Which will be the 28th at 9 a.m.
Is that going to be a settlement again, Your Honor?
Correct. And I mean, we have these other outstanding issues that we need to address, but I want to talk about this protective order for a minute. So I reviewed the protective order. 99% of this is standard protective order language. Okay. Whether it's a defendant or a defense attorney, the order is clear. It applies to both the defendant and counsel. And what the order says is that to protect the privacy and the sensitive nature of the documents, and it's all documents that could be included in the discovery, and that if they're given to the defendant, they cannot be disclosed or posted to any third parties via social media or digital means, which means, Mr. Crowley, if you get a copy of discovery, you can't post it on the internet.
Your Honor,
can't share it with people.
If I may, nobody can keep a secret in your courtroom better than I can, Your Honor.
Well, here's the thing, Mr. Crowley, though, you just said that you felt that this violated your confrontation rights to confront your complaint. It does not.
Okay. Well, I believe that if I sign that, I'm hindering myself with regards to being able to question people, do that whole cross-examination thing. I got to be able to investigate as my own attorney. And I'm just not going to sign it, Your Honor.
All right. Well, I mean, you don't have to. I can order it whether you sign it or not. I mean, all the prosecutor's asking is that you not disclose the information.
Yeah.
Right? Yeah. And that means you can't post it on the internet. You can't send it to your sister, cousin, brother, uncle. You can't send it. You can't harass the complaining witness with it. You can't send it to her mom. You can't. It's for you to prepare for your case. It's not for you to have a court to have a trial in the court of public opinion. It's not to be shared or disclosed.
Your Honor, I understand this, and I understand and respect the court's decision. I will honor the court's decision, but I do not want anything redacted. And that's what the prosecution told me that was for. If I sign that, that makes some information redacted to me.
Well, some information is supposed to be redacted. I mean, if we find out, if there's something in there about, like, I don't know, this is an example where Miss Ashby is currently residing. You don't need that. It doesn't go to one of the elements of the offense. Yeah. If her driver's license number is in there, you don't need that information. There's information contained in police reports and in other discovery documents that there might be an eyewitness who gives their driver's license number. And that's not information that you would be entitled to in discovery, or social security numbers, for all I know.
Yeah, no, I understand.
That is the type of personal protective information, is the type of information that would be redacted. Information that you're not entitled to. So, Mr. Crowley, when you present your defense, every offense has elements. Right? And information that goes to those elements is stuff that must be given to you. Exculpatory information is information that must be provided to you. But identifying information relating to the complainant or other witnesses is not information that is to be given to you. I mean, and that is the type of information that would be redacted. Am I correct, Madam Prosecutor?
Yes, Your Honor.
I mean, that's the kind of thing that they take out.
Well, Your Honor, if I could get one of those proposals specifically stating that they want to redact those social security numbers, driver's license numbers, that's fine. But anybody who claims that they have evidence against me, I'm not redacting it. And I don't mean to be disrespectful to the court, but I'm not signing it.
All right, well, you don't have to sign. I can order it without your signature. But let me go over one thing in the order that I did want to ask Madam Prosecutor about. On the last paragraph of page 2, it says that the information can be used for educational purposes by the Wayne County Criminal Defense Bar.
Yeah, Your Honor, this was a boilerplate motion or there's order we had. We can strike that.
I'm striking that. I mean, there's no, he doesn't have to agree to have his information become a tutorial.
Yeah.
Yeah, but they want it redacted.
Yeah, it has to be.
Yeah.
You've made your record.
Copy that, Your Honor. Can I move for a dismissal right now at this time, Your Honor?
I mean, you can move for one.
I would like to move for a dismissal based on discrimination in my case since February 3rd at the time that this has begun, based on the Constitution of Michigan in 1963, Article 1, Section 2, under the Equal Protection.
All right.
Everything in my personal experience with the police all the way to this moment since February 3rd, Your Honor, I'm on my 5th settlement in order for the prosecution to collect evidence against me. I'm on my 2nd bond hearing I had 1 bond hearing in which I didn't even defend myself because of my attorney. I've had an attorney I've had to fire because there's no defensive legal strategies whatsoever on my behalf. And I believe wholeheartedly that this is a direct violation of that Constitution of Michigan, Your Honor.
Okay. I've overseen this case since the case's inception. I did not do the original arraignment on the case, but otherwise the case has been in front of me for all proceedings. I believe myself to be fair and impartial. These are procedural hearings. This happens in every court case. So there's nothing unusual about the procedure. I'm not dismissing the case at this time. I am adjourning the case 1 week to 4/28 at 9 a.m. Parties can continue to appear on Zoom. Bond conditions will continue. There is to be no contact with the complaining witness, and all other bond conditions that were previously put in place remain. I am entering the protective order. I am just asking the prosecutor to submit a copy. I'm not going to X out a copy. So I've X'd out the last paragraph on page 2. I want an order presented to this court consistent with the version I've signed already, so that we have a nice, clean protective order so that it can be provided to Mr. Crowley so that he can obtain discovery on this case.
Yes, Your Honor.
Thank you, Your Honor. Your Honor,
All right.
Your Honor, if I may ask you a question, please. I have a witness list that I would like to submit to the court. How do I give that to the prosecution, or do I just wait until I'm in the jury?
Well, we don't have a trial until July 25th. Okay, you have to submit your witness list within 30 days of the date of trial under Michigan court rules. So you can submit your witness list, and anything you send to the court, you must send to the prosecutor. That's how it works. Anything she sends to me, you have to get. I'm not supposed to be reviewing any documents that both of you aren't privy to without some sort of legal exception to that rule. So I'll enter the protective order when a prosecutor provides. I'm just calling it a clean copy, but we know what I want, okay?
Yes, ma'am.
All right, we'll see everyone next week, 4/28 at 9 a.m. Bond continues.
Thank you, Your Honor.
Yeah, and here, Madam Prosecutor, do you want this order, just so you know what I'm looking for?
Yes, please.
Can you hand that to Madam Prosecutor? Here's this. Okay, and we're all set. Bond continues. Ms. Ashby, Mr. Crowley, you're excused.
All right, thank you, Your Honor.
Thank you.
I can
All
leave
right.
now. Right?
You sure can. Are we ready on Llewellyn?
Yes, Your Honor.
Okay.
All right, let me
Complaining-
get him in here.
complaining
Oh,
witness.
Mr. Llewellyn's here.
The victim needs a friend, needs somebody with her. She shouldn't be there by herself. She needs some support. That's going to be a storm, a Chad level storm next week. That was earlier this morning that went down in Judge Shackelford's courtroom. All right, we're going to go to lunch. We have a little bit of a break before Lori Vallow starts. We have jury instructions and closing arguments and then deliberation. Of course, first Lori Vallow is going to have to rest in front of the jury officially. Like, finally, this is my final decision. No more witnesses. I'm not going to testify. There's still a chance, odd chance, but I don't think she'll do it, that she says, I changed my mind, thought about it over the weekend. I'd like to talk. I don't think that's going to happen. So that's the order we think it's going to happen. And we're going to go take a lunch break. And even though I've already eaten most of the stuff, I'm going to go check on the boys who are working in the room next door, building in the bathroom. And then we're going to come back and we'll see what the evidence did not show. All right. Tonight when you go home, please talk to people you love. Smile at someone, make that day just a little bit better. Please stay safe till we go live again in about 45 minutes is when it starts. So we'll be back for Lori Vallow this afternoon. Tomorrow, Karen Reed starts. That's going to kick off Karen Reed round 2. That's going to be interesting. I think you're going to love it. Let me tell you this. I'm interested to see how defense begins with their opening statement. And if Alan Jackson gets up there and stands up there and says one more time, looks at the jury and says, Karen Reed was framed. That's going to tell me so much about what the defense thinks about their prior defense and how they approached it. Interesting to see if he'll do the same thing with a new jury, if we'll have a new approach. So I can't wait to see that. We'll be back for Vallow in a little bit. You guys have good lunch. We'll see you. Bye-bye.